Decades later, VMI honored Justice Ginsburg in recognition of the contributions its female alumni have made. Justice Scalia was the sole dissenter in that case and even accused the court of destroying VMI, which remains standing and strong to this day. Now, I'm just getting at how closely you would ally yourself with Justice Scalia's jurisprudence. Would you agree with Justice Scalia that Justice Ginsburg's decision in VMI was wrong?
Well, Senator Coons, to be clear, as I said, I think in response to this question yesterday, I do share Justice Scalia's approach to text, originalism and textualism. But in the litany of cases that you've just identified, the particular votes that he cast are a different question of whether I would agree with the way that he applied those principles in particular cases. And I've already said, and I hope that you aren't suggesting that I don't have my own mind or that I couldn't think independently or that I would just decide like, oh, let me see what Justice Scalia has said about this in the past, because I assure you I have my own mind. But everything that he said is not necessarily what I would agree with or what I would do if I were Justice Barrett. That was Justice Scalia. So I share his philosophy, but I've never said that I would always reach the same outcome as he did.
Understood. But I think a case like this is a striking example of what it might mean to replace Justice Ginsburg and her methodology and her approach with someone much closer to Justice Scalia. And frankly, to me, this comes back in part to the president who nominated you. President Trump did not nominate you to carry on Justice Ginsburg's legacy. He nominated you because he wants to undermine or change or shift that legacy. And he's been very clear repeatedly before you were chosen about his intent to nominate justices in the mold of Justice Scalia. You recognized yesterday in an exchange with Senator Leahy that replacing Justice Scalia with Justice Garland, had Judge Garland become Justice Garland, would have changed the balance of the court. It's something you wrote about in 2013 in the Texas Law Review. You recognize these balance shifts are why Supreme Court nominations are so much at issue in presidential elections. Do you just acknowledge that your confirmation, even though you won't be identical to Justice Scalia, will profoundly impact the balance of the court and the way in which it decides future cases?
I think the statement that I was having an interchange with Senator Leahy about yesterday was about an interview that I gave shortly after Justice Scalia's death, but after Judge Garland's nomination. And I did say that, use that phrase, lateral move. And what I meant by that, I very much agree with Senator Sass that we shouldn't talk about Republican judges and Democratic judges because I think there are just judges. But of course it's true that judges have differences in judicial philosophy. So I actually think Justice Breyer and Justice Scalia are a great example of this because they sometimes have public debates with Justice Scalia advocating originalism and Justice Breyer advocating active liberty. And there's room on the court for that, for having different approaches. It's not about having, your colleagues on the other side of the aisle, all of you in the room have different policy platforms, but judges don't have policy platforms, but it is certainly the case that judges take different approaches to interpreting the text. And that is what I meant when I was describing how the balance of the court would shift. It would be away from one balance and toward another in terms of how judges think about the text.
And Judge, what I want to explore with you in the time I have remaining is exactly how those shifts in methodology, in approach, may well have a dramatic impact on the policy outcomes, on what is and isn't upheld as law going forward. On the board behind me, I've asked my team if we would just go back and look at cases. All of these cases listed, it's roughly 120, have something in common. Justice Ginsburg was in the majority, Justice Scalia was in the minority dissenting. And these are cases that touch on nearly every aspect of modern American life. I've talked a lot yesterday about healthcare and the Affordable Care Act. Yes, that's on there. A number of my colleagues have talked about some other areas. But what's striking is if you just look at what a 5-4 balance towards this methodology means if changed towards a 5-4 balance to this methodology, it has huge consequences for education, for consumer rights, for access to the courts, for civil rights, for immigration, for environmental protection, for Native American rights, for workers' rights, for elections, for executive power, for reproductive rights, for free speech, civil justice, economic development, privacy, government misconduct, prisoner rights, capital punishment, gun safety, and criminal justice. In each and every one of these cases, if Justice Ginsburg had been replaced by a justice with the same core methodological approach and view of the law and decision-making, you can't predict exactly how the case would have turned out, but in virtually every case, it would have moved in a different direction, and in a direction much closer to Scalia's philosophy and farther away from Justice Ginsburg. And that's why I think your views on precedent matter, and we should take a few minutes and go through them. It's something you've written about at length and where you're quite well-grounded. The precedents of the court, which is what these 120 cases are precedents upon which litigants, the average American, should be able to rely. And that's that whole issue about whether justices are simply umpires calling balls and strikes or whether there is some agenda. My concern is that a leading scholar in the field of constitutional law has recently reviewed your writings and concluded that you demonstrate an extreme willingness and even radical willingness to revisit settled precedents. Some characterize you as more extreme than Justice Scalia in your approach to precedent and closer to Justice Thomas. The Supreme Court has long held, as you well know, that overturning precedent, a settled case, requires a special justification or strong grounds. But in a 2003 article in the University of Colorado Law Review, you wrote, and I'm quoting, and I think I'll get a chart here in a second that has this quote, "Generally speaking, if a litigant demonstrates a prior decision clearly misinterprets the statutory or constitutional provision it purports to interpret, the court should overrule the precedent." What I see missing from this text and the broader context around it was anything about needing a special justification to overturn settled law or anything about the other factors the Supreme Court typically requires. You seem to be saying a judge should overrule any precedent as long as she thinks it's clearly wrong. If that's your view, and I think from this text it is, it basically means any precedent is at risk where your originalist view of the Constitution or textualist view of the statute says it's clearly wrong. Do you stand by this statement?
Senator Coons, that statement was talking about the courts of appeal. I believe that statement was about the due process clause, and as you probably stretch back from your lawyer days, remember the principles of issue preclusion and claim preclusion.
Right.
And that article was about how in the courts of appeals it had a very rigid rule that one panel couldn't overrule another, that those rigid rules in the courts of appeal were inconsistent or in tension with some of the court's issue and claim preclusion doctrine. So it wasn't about normal functioning of precedent, especially at the Supreme Court where there are no such rules. And I'll point out that the article was about circuit courts and courts of appeal, and in my time on the Seventh Circuit, I don't think there's any evidence that I've been unwilling to follow or apply circuit precedent. As for the scholar criticizing me as a radical on stare decisis, I'm not sure who it was or the substance of the criticism, but I'm very surprised because I think it was my conversation with Senator Feinstein earlier. I explained that the article, which many people have plucked a sentence from, the Texas Law Review article, was a defense of the Supreme Court's approach to constitutional stare decisis.
If we can, let's move to that quote, because your words weren't just limited to this context, to talking about individual litigants versus how issue preclusion works. It was a novel analysis, the 2003 article, something I hadn't thought of about how stare decisis impacts an individual litigant. But in this 2013 University of Texas Law Review article, which has also been referenced today, you wrote, and I'm quoting, "It's more legitimate for a justice to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it." Again, you're saying that if a Supreme Court justice thinks a prior ruling was clearly wrong, she should disregard precedent with which she disagrees, regardless of the typical balancing factors.
Senator Coons, with respect, as I explained this morning, that sentence has been plucked out of the article to kind of, I think, create a misimpression about the context. The whole article discussed reliance interests, discussed the reasons for stare decisis, and emphasized that courts ought not disrupt settled precedent, absent very good reason to do so, reliance interests being one. And I think that no one on the court, or even no one in this room, would think that the court ought never revisit its precedent. As I was mentioning, maybe it was to Senator Leahy earlier, you know, Bowers versus Hardwick held that certain sexual conduct between same-sex partners was illegal. It was criminalized. And then Lawrence versus Texas overruled that. And my guess is that you think Lawrence versus Texas was correctly decided. So I don't think, Senator Coates, that your position would be that no precedent should ever be revisited.
Correct. I do think in grievously wrong cases, it is appropriate to reach back, as a number of members have discussed around Brown versus Board and Plessy, and I did note that exchange earlier. But in terms of reliance interests and the significance of reliance interest, in reading that 2003 Colorado Law Review article, you wrote that reliance should count much less, if at all, when a litigant convinces a court that precedent conflicts with the statutory or constitutional provision it purports to interpret. I was struck by that language because I know you choose your words carefully. You've acknowledged reliance interests exist and they're part of the Supreme Court and its approach. But in this article, it seems to me you're giving your own views about whether reliance should matter. And you're unequivocally stating it shouldn't. It should matter less, if at all, when the originalist approach to reading the Constitution says this is wrongly decided. That's why, to me, the concern about reading the Constitution through a Scalia lens rather than a quite different, methodologically, Ginsburg lens. You've also recognized originalists like yourself are more likely to overturn precedent. In the Texas Law Review article, you cited statistics that self-identified originalists like Scalia and Thomas urged and joined in overruling precedents more than any other justices over an 11-year period. The disturbing picture to me overall about all of this, about precedent, is that I think there's been a movement amongst originalists and a change in terms of the approach of judges to judging who self-identify as originalists. In the 2017 article in the University of Minnesota, in Constitutional Commentary, that's been referenced before, you said, and I'm quoting, about modern originalists, that they've abandoned the claim one should be an originalist because originalism produces more restrained judges. Do you stand by that characterization?
Well, Senator Coons, I just want to point out that in this whole discussion, you know, I did write that Colorado article in 2003. I don't recall that sentence or its context, but in my full body of work, including everything that's come before, including the 2013 Texas Law Review article, I've written at great length about the virtues of stare decisis and the stability interests it serves. And in my scholarship, I've also talked about other features of the judicial system. And also, I'd like to point out that nothing in my record in the Seventh Circuit shows disrespect for stare decisis. And also, Justice Scalia did observe and follow precedent. It's not like Justice Scalia ever advocated an overthrow of stare decisis. So I just don't think there's any evidence to suggest that I'm in there trying to burn up the 600 volumes of the United States reports that are on the shelf. I don't have an agenda in that regard.
Well, that's so exactly what caused me concern as I looked at Thomas versus Scalia, and which may be more the role model you follow in terms of the application of stare decisis. These quotes jumped off the page. I haven't made a practice of reading 50-page law reviews recently. I don't mean to suggest
recommend it.
they were compelling and well-written. But these quotes struck me as clear statements of a view or an intent. And as I've said before, the larger challenge here is not what you've said about your views on cases, but what the president who has nominated you has said about his goals and his objectives for your service on the court. And frankly, my concern about originalism and an activist willingness to reconsider precedent is that in combination, Justice Scalia's views, often expressed in sharply worded, memorable dissents, may make for great academic reading, but I think most Americans don't expect them to become the law of the land. And in a long line of cases, they would overturn well-settled precedent that I think we have all come to expect. So my core concern here, Your Honors, that your confirmation may launch a new chapter of conservative judicial activism, unlike anything we've seen in decades. And the point of the chart was to just show, we've mostly been talking about the Affordable Care Act and privacy-related cases. But if that's true, it could touch virtually every aspect of modern American life. I pray that I'm wrong. I hope that I am. But in my reading of your work, nothing has alleviated my grave concerns that rather than building on Justice Ginsburg's legacy of advancing privacy and equality and justice, I'm concerned, in fact, you will take the court in a very different direction. And so with all due respect, I will be voting against your confirmation, Your Honor. Thank you, Mr. Chairman.
One brief comment. The 6 super president cases, how many were there? 5, 6? I don't know.
Oh, let's see, this is going to be just like when Senator Sass asked
Well,
me
we
how
know
many
where they're
freedoms were. There was Marbury, there's Brown, there's Mapp versus Ohio, there's the civil rights cases.
So just very briefly for the public. And the reason those cases were picked by you, nobody is suggesting in today's world that it's not the Supreme Court's decision to interpret the Constitution, Marbury versus Madison.
That's correct. And to be clear, that list was formulated by other scholars.
Right.
I was referring to it. But
Not
yes,
just your list.
nobody thinks that Marbury versus Madison and the court's
Yeah,
authority
right.
to interpret the Constitution.
And nobody in America is wanting to go back to segregation. No
No.
legislative body is attempting to do that for a good reason. America does not want that. Nobody in their right mind wants that. The rest of these cases that have been listed as super president have that commonality. Overwhelming acceptance, is that correct?
Yes, that is correct.
As to Roe and Casey and to Heller and to United Citizens, active litigation going on right now today. Is that correct?
That is correct.
Senator Hawley.
Thank you, Mr. Chairman. Judge Barrett, good to see you again. Are you aware of any active litigation challenging the constitutionality of Griswold versus Connecticut?
I am not.
Are you aware of any litigation in recent decades challenging the constitutionality of Griswold versus Connecticut?
I am not.
Are you aware of any legal movement out there to challenge the constitutionality of Griswold versus Connecticut?
I am not, although Senator Hawley, as I said to Senator Coons, I'm certainly not aware of anybody trying to make the argument that a legislature should prohibit the use of birth control. But as you know, Griswold does lie at the base of the doctrine that very much is challenged in federal court.
Here's my point. I was 7 years old when Judge Robert Bork came before this body. I don't remember any of that. I wasn't watching it as a 7-year-old. But what we saw, I think the legacy of the Bork hearings continue to reverberate. His name has become a verb, the borking of nominees. I think what we've seen today is an attempted borking of Judge Amy Barrett. The problem is they don't have anything in your record that they could use to so badly misconstrue, to suggest that you're somehow going to fundamentally change America, that now they have to attribute to you the worst readings and most draconian misinterpretations of Justice Scalia. So we take Scalia's record, we distort that, and then we attribute it to you. So let me just come back to your relationship with Justice Scalia. I was under the impression that you were a different person than Justice Scalia and that you had, in your own words, your own mind. Is that fair to say?
That is fair to say.
Is it fair to say that you are an independent woman and an independent jurist and an independent professional and also, by the way, a pretty darn good lawyer, and you'll make up your own mind on the decisions, cases, controversies that come before you to the Supreme Court of the United States? Is that fair to say?
Yes.
I think maybe then we can put to rest this attempt to constantly leverage the worst interpretations of Justice Scalia's philosophy, misrepresentations, and attribute them all to you as if you are the same person. Frankly, I think it is demeaning and insulting. And I'm glad that you pointed that out in response about your independence to the last question. Let me ask you about another set of questions, just briefly you had this morning. Senator Leahy asked you about the Foreign Emoluments Clause, which is in Article 1, Section 9, Paragraph 8. He asked you whether it was best characterized as an anti-corruption clause. You might remember that in terms of foreign influence and foreign interference. And then he referenced the president and various allegations about foreign influence. Since he asked you about it, and since he asked about foreign influence in government, I think it's only fair that I ask whether, hypothetically speaking, just hypothetically, if there were, let's say, a vice president of the United States who hypothetically had an adult son, who hypothetically worked for a foreign oligarch, who then sold access to his father, the vice president, and his father then intervened in a case to make sure that that oligarch wasn't prosecuted, hypothetically, would that constitute the kind of foreign corruption that the Constitution's concerned about?
I can't answer hypotheticals.
Well, I thought you might say that, and I'm glad you don't and won't, because who knows, that case may come before you, but I think it's a fair set of questions to ask. Let me ask you about something different. Section 230 of the Communications Decency Act, passed by Congress in 1996. Yesterday, Justice Thomas issued a dissent from a denial of certiorari in a case called the Malwarebytes case. Now, I bet you haven't had a chance to see his.
I was just about to say, please don't ask me about it, Senator Hawley, because I didn't have a chance to read anything.
Well, let me read to you just a few parts of it. It's quite significant, I think. Here's from the opening paragraph. When Congress enacted the statute, meaning Section 230 of the Communications Decency Act, most of today's major internet platforms did not exist. And in the 24 years since, we have never interpreted this provision, we meaning the Supreme Court. But many courts have construed the law broadly to confer sweeping immunity on some of the largest companies in the world. He's talking about the big tech companies. And he quite methodically, over 10 pages, goes on to set out the ways in which courts, at the behest of these tech companies, have dramatically rewritten Section 230, changing its liability standards. He talks about changing the distinction between publisher and distributor liability, changing the immunity shield, changing the narrow liability shield, extending 230 to protect companies from a broad array of traditional product defect claims. He says it's quite a thorough statement. Here's my question to you. You haven't read this. I don't think you've had a Section 230 case.
I haven't.
So in general, not about his dissent from denial, but in general, what are the dangers of the Supreme Court or any court rewriting a statute, departing from the text that Congress or a legislature, a lawmaking body, departing from the text they have written, that has been adopted, presented and adopted? What are the dangers in that if a court departs from that and substitutes its own judgment, whether it's done in one opinion over a series of years?
So as you've posed the question, without respect to Section 230, just in general, the danger of a court doing that is to subvert the will of the people. You represent the people, as has been pointed out over the course of the hearing. Judges are not elected and they have life tenure and can't be voted out of office. So if judges misconstrue statutes or bend them to the judge's idea of what would be good public policy, then it deprives the people of the chance to express the policies that they want through the democratic process.
And the effect can be cumulative, can it? I mean, you can start with a change to the statute, a rewrite of one provision of the statute that then becomes precedent, and then when the court revisits this case later, revisits the issue later, then they expand that and do a little more rewriting, and pretty soon, 5 or 10 or 15 years later, you're with something that has been so heavily blue-penciled, so to speak, that it doesn't bear much resemblance at all to the original statute. I mean, that's a danger of courts continuously substituting their own judgment. Is that fair to say?
That can happen.
So, let me just say, my opinion, not yours, I think it's pretty clear that has happened with Section 230. I think Justice Thomas does an outstanding job here of laying out why that's the case. Let me ask you in a related vein, Justice Holmes, Oliver Wendell Holmes Jr. said in the famous Lochner case, in his famous dissent in that case, over a century ago, he said the 14th Amendment does not enact Mr. Herbert Spencer's social statics. Do you agree with that statement? What do you think he was getting at with that?
So Justice Holmes' famous dissent in Lochner, which was later the position adopted by the court, is that, courts shouldn't pour their ideas of good economic policy into the 14th Amendment to stand in the way of policies that the legislatures enact, for example, on questions of maximum hours for bakery workers or minimum wages and those kinds of things.
You mentioned economic policy. Talk to us a little bit about how a court could substitute its own views on economic policy for those of a law enacting body, the legislature or of Congress.
Sure. Well, in that era, in the Lochner era, and then we saw it also in the cases that preceded the switch in time, the court was standing in the way, I guess in Lochner itself, in the way of reforms for workers that legislatures were enacting. And so if, say, one had a preference for free trade, or if one had a preference for having no minimum wage or having a minimum wage, to hold such a statute that did the opposite of your policy preference unconstitutional because it didn't comport with your idea of the best economic policy would be to thwart the will of the people without warrant in the Constitution.
Are there dangers in courts acting as, let me preface this by saying, most judges are not economists. I suppose some may be, but most judges are not economics experts. Are there dangers in general with courts acting as economic policymakers, deciding economic policy, making economic judgments? I mean, is that something that courts should be wary of as outside their area of expertise?
Well, I am certainly not an economist. I think courts are expert in interpreting law. You know, we've been trained in law schools, and that's what we're good at, and that's what we should stick with.
I raise these concerns, and I raise them in conjunction with Section 230, because it seems to me that in the closely related antitrust context, we have seen over a period of many years courts substitute their economic judgment in many cases for what the words of statutes actually say and what perhaps the fairest interpretation of statutes might actually be. And whether it's Section 230 or the antitrust laws, one effect of this is to see growing concentrations of power in this country economically that I think are very significant threats to the ongoing operation of our democracy, to the basic ability of the people to control the levers both of the economy and of culture and of government. And I'm afraid I think that courts have some role in this in much the way that Justice Thomas suggested in his dissent from denial yesterday. And I think it's hard to ignore it in the antitrust context as well. So I won't ask for your view on this because these are cases, these are issues that you very may well be called upon to weigh in on. I hope that you are. But I hope that you will give these issues consideration and the I think very well taken warning of Justice Holmes in Lochner. I think perhaps that insight has been lost sight of in many cases by both Republican appointees and Democrat appointees over many years on the Supreme Court in a variety of areas. Let me transition to one other area of law that's very important, back to the First Amendment and to the free exercise of religion. You had an interesting free exercise case recently. You were on the panel. You didn't write the decision. This is the Pritzker case. Illinois Republican Party versus Pritzker, decided on September 3rd of this year. So it's quite recent. It was just last month. This is a case in which the governor of the state was sued because, in the words now of the opinion I'm quoting, his executive order relating to COVID lockdowns, quote now, exhibits special solicitude for the free exercise of religion. And the case, in a roundabout way, challenged that special solicitude for churches and religious organizations. You joined the opinion in full. You didn't dissent. Can you say why you joined the opinion and why you think that the content here is right, why the holding is correct?
Sure. So in that case, the Illinois Republican Party said that because the executive order in Illinois had given an exception for the free exercise of religion, for example, so that people could gather at churches or synagogues or mosques, that same special protection had to extend to the Illinois Republican Party and indeed, by logical extension, to everyone, so that the whole order would fall, because religion couldn't be singled out for special treatment, and that right to free speech, free assembly, et cetera, that it was, under First Amendment doctrine, a content-based distinction that could not survive. And what that opinion said about that is that it was permissible for the governor of Illinois to carve out an exception for free exercise, and that doing so didn't compel the government to extend the same protection to everyone. As Judge Wood said, very well in that opinion, trying to accommodate a right explicitly mentioned in the Constitution and the First Amendment did not put the COVID order in jeopardy.
And the opinion is very firm on this point. You quote from the Hosanna Tabor case, which you and I discussed a little bit yesterday, unanimous case from the Supreme Court. This is the opinion quoting from that case. The First Amendment itself gives special solicitude to the rights of religious organizations. That's the Hosanna-Tabor case. This opinion that you joined goes on to say there can be no doubt that the First Amendment singles out the free exercise of religion for special treatment. Rather than being a mechanism for expressing views, as the speech, press, assembly, and petition guarantees are, the free exercise clause is content-based, as you just said. The mixture of speech and music and ritual and readings and dress that contribute to the exercise of religions the world over is greater than the sum of its parts. In other words, what I understand, correct me if I'm wrong, what I understand the panel to be saying is the free exercise of religion isn't reducible to the free exercise of speech. It isn't reducible to the free exercise of assembly. Those are important rights. Those are also protected by the First Amendment. But the free exercise of religion protects something different and more. It protects the rights of religious people and religious organizations of all backgrounds the world over, but of course, in this country, for Americans, it protects them and gives them special solicitude under the First Amendment. Have I got that correct?
Yes, to be clear, I can't take credit for the eloquent language. That was Judge Wood's language on the panel opinion that I did join. Yes, but the point that the panel opinion makes is that the free exercise of religion is singled out for its own protection in the First Amendment rather than being a subset of speech. And the position that the Illinois Republican Party took in that case would have been more putting everything under the speech umbrella.
And why do you think that is an important point of constitutional law? If I could ask you to put on your, I'm not asking you to comment on cases, but if you could put on your constitutional scholar hat, why is it significant that the First Amendment gives special solicitude, as this decision says, as the Supreme Court has repeatedly said, special solicitude to the rights of religious associations, religious believers, religious worship and exercise?
I think that case itself, the Illinois Republican case, shows why this distinction can matter, because as our panel held in that case, the outcome may have been different if we had been treating it solely as a free speech question, because the court has said that content-based distinctions, under the First Amendment get strict scrutiny and it can be hard to satisfy. But so the case might have come out differently had it only been speech at issue. The case came out as it did because free exercise was also at issue.
I think in this time when we see many challenges to the rights of religious organizations, their ability to meet freely, and where frankly we see many instances around the country where religious organizations are treated, religious churches, synagogues, mosques are treated less favorably than secular counterparts, whether that's casinos or gyms or liquor stores, you name it. But so many different executives around this country have chosen to single out churches for disfavor, whether it's in the COVID context, which is what this case is about, or another context. I think that the holding of this opinion is very, very significant, and the Supreme Court's doctrine on this line of cases about the rights and the special solicitude, in the court's words, for religious organizations is very, very significant. I'll just conclude by saying, Judge Barrett, that it's been a privilege to get to speak with you these last couple of days. Congratulations to your family and to Jesse, and I think you have been, your answers to these questions have been really, really exceptional. I have been extremely impressed, and I was impressed to begin with. And I just want to put a finer point on something that Senator Sass said earlier. He said, you exercised your rights of assembly and free exercise and free speech when you were a faculty member. We've talked about that at length in various positions you took, and he pointed out there's nothing wrong with that. You shouldn't be penalized for it. I just want to agree with the chairman that I think there's nothing wrong with confirming to the Supreme Court of the United States a devout Catholic pro-life Christian, and it will be my privilege to vote for you.
Thank you.
Thank you, Judge Barrett. Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Welcome back, Judge Barrett, and to your family as well. I hope you got some rest last night. I think that's true of all of us.
So I did have a glass of wine. I'll tell you that I needed that at the end of the day.
Well, let me just say on that kind of point, you have a right to remain silent. First, Mr. Chairman, I'd like to enter into the record some letters from the National Council of Jewish Women and 86 Jewish organizations, from gun violence prevention organizations, and from the pro-choice caucus.
Without objection.
Thank you. There are a couple of loose ends that I'd like to clarify from our conversation of yesterday. First of all, in our discussion of the Second Amendment, we both made reference to the Third Circuit and its ruling on whether or not individuals convicted of a crime could possess a firearm. And I think you cited the Third Circuit as supporting the idea that certain felons could possess firearms, if I'm not mistaken.
And I went back and checked that too. And so you're right, it was a splintered decision. And I was thinking of Judge Hardiman's opinion, which was close.
Gentlemen, this is Bentley in the hearing room. Can you hear me? It seems our entire sound system's down in here.
He walked that way and all the sisters walked that way. They were literally like in like footstep with each other. I know. Like,
Yeah, they didn't know custodian
Yes, thank you.
all the mic stuff working.
Yeah, I just saw that on a tweet. It's like, taking a 10-minute break, mic's dead.
Yeah. I think the mic's are coming off.
There was a fly on her yesterday. Mic's dead. How long ago did she just cross over?
4 minutes? 3 minutes? Is it okay if I point out that she's wearing the shoes as Monday?
I would.
But not the same shoes as yesterday. I mean, she probably has more than 2.
No, she has 2 pairs of the same shoes.
No, because she wore pink shoes on Monday, and then she wore tan pumps yesterday, and she wore pink shoes.
I don't even know what shoes I wore yesterday. Oh,
You
Steve.
wore those?
I come from an Italian family. Shoes come up. He said that's what they be like.
My goal was a pair of shoes for every day of the year, and then I realized that my closet's not that big.
Is this okay for you here if I'm down?
Maybe just kick the wire out. Yeah, that's perfect.
No, we can, no, but.
You stay seated there.
Yeah, I'll stay seated.
Right there, Laura. Got like right over you.
The mic, right? Okay.
Kristen, you're good?
I'm gonna pop, if you're gonna.
I'm gonna go here to behind Saudi right when
Okay,
she comes
then
out.
I'm gonna pop over to the other.
I want to make sure you have what you want. Totally. This is your pool position.
Do you want me to go to that door or anticipate this door?
Anticipate this door.
Okay.
And I'm gonna stay out of your way for right now.
Yeah.
I think they're all still in there. I think she's the only one who's left.
Come by yourself.
I mean, she would with all of it. Yeah. But like Grant just walk out or.
I was having a coffee break. Went out.
No, sisters. Huh? Oh no, they're all her sisters.
So the microphones all went out, or is that just the sound system? The sound system went out?
Five sisters. Oh, yeah, but no, just. Did you do the horse or did you need to go?
No, they
Five sisters and one brother. No, she has 5 sisters, and one brother, there's 7.
house in the big church on 16th.
Oh, I lived on Hobart Street.
Okay, totally know what that is. And you need to go for a walk. We got a route that goes all the way to the bottom of Adams Hill, or if you want to do the long one, just go to 16th Street, hike to Missouri and back. So that's like a 4 or 5 miler.
You need some union audio people in that.
I know, they should just ask the TV people to go and fix it.
Yeah.
They need the roadies from Spinal Tap to work there.
They're ready to learn.
Remember when all the networks had lighting guys?
Oh, yeah.
There was
Audio
many,
guys.
there was many sound guys as there were camera guys. Man. Used to when we had big hearings on the Hill, you know, the network lights would come in and it was cinematic.
Oh, man, they found a World War II bomb
Oh, I saw that, yeah.
in Poland, underwater in Poland, and they tried to defuse it and detonate it.
It was a big one.
Yeah, defuse it.
It was like a dam buster, a bridge.
I was working on a project in that, it's called Norway gets 400 calls a year for their problem. Because a lot of people don't realize that 29 tanks they take back, one gun out. So 4 guys in each tank. Like over 100. Yeah, over 100 guys.
Every American should go to.
I know, I wanna go, I just haven't.
Canadian and Brits too. You know,
Yeah, oh yeah, I know, but I'm just saying, because the way Americans talk about the French, you know,
Like
ignorantly.
dismissively and whatever.
Yeah, I mean, if you ever want to go someplace where they love Americans,
Oh, yeah.
go to Normandy.
So I started with Sword and drive south.
Sword, Gold, Juno.
Yeah, all the British beaches in the I got to some part, and you're in sometimes in someone's backyard, and I was just looking at some pillboxes, like they're, when the tide comes up, the pillboxes are in the water. I was just looking at, and from this fall, this farmer comes up, and I'm like, oh, sorry. He goes, no, he goes, where are you from? He goes, please, you have to come have a coffee. And I was like, they would not take no for an answer. And he goes, my cousin lived near Long Beach, and he makes dinner, like, literally.
I'm not kidding. It's total ignorance. Yeah.
The same for, if you go to the Netherlands, especially the liberation anniversaries.
Guess we'll be here a little later tonight, huh?
Just a little, sounds like it's a major circuit breaker issue.
Here we go. Not sure why. if she goes in the door, I'll get in. Probably.
But it's true, that guy's an operator, he's very smart, he knows how to make things happen up here.
Oh, yeah, no, Eric was great.
I really think that it's noticeable that he's missing.
Yeah. No, that was really smart.
When he handles them, I mean, like a machine, he's super pro.
Yeah. He, there was one night we had this like group camp going. And, at one point, we were waiting and it was just like the back and forth and back and forth and back and forth. And Haley out there and sees Eric and goes, "Are you doing anything tonight or?" And he's just like, and I asked him, "Where'd you come from?" Oh my God, did you just ask?
That's funny.
Doggy.
She turned red.
Oh, yeah, it was hilarious.
I like Haley, she's really cool.
Now we bust on her all the time. Anytime somebody talks about you and we're like, "Haley, you doing anything tonight?"
That's very funny. Yeah, I got to know Haley pretty well during the impeachment. I mean, we all see each other up here a lot, but a lot of times we're not all up here at the same time. Like setting up like that, I got to know you, a lot of different people. Everything involved for space and crowding.
Tons of outdoor light.
I do, because I'm not saying we, just meet all of their people who just came in here at the last minute and crowd.
Yeah. I mean,
I find it interesting.
it's a roller coaster of how it's hard.
Well, I think that, and I was, you know how I work. This is your position, and we're just guests. So I want to make sure you're always happy and that I can work around you as you guys need the space.
Yeah, it started feeling a little pushed in.
You're being very, very generous.
I was not very generous yesterday when I was doing nothing.
Well, I do think that, someone had to make a point of it, and, the rulers of it. What happens is, describe it, and just stuck in here at the last minute.
Okay, so maybe we're gonna say at least 10 more minutes.
We work up here 365, right? We work up here all year. Pros. Never be perfect.
Anything you want to get off your chest?
Another day of doing magic.
So much.
Okay.
You know what, Scotty, I didn't see it. I'm like, where'd Scotty go? And I just heard a voice, and I'm like, oh, Scotty's got a voice.
I know.
Chris, the thing is sometimes,
They're just offering
it's
therapy
opportunities.
opportunities.
It won't be the same way every year. We felt like we should do that, and that's important to do, and now there's some better rules everybody's got here today, so. It can never be perfect. And I definitely have had my moments,
Just assert yourself.
Just inserting myself in like the full like tilt that I would
There's
get.
too damn many people up here.
Yeah.
I think you felt like it was time to make some noise, you know, things are a lot nicer.
Dad, my wife.
What? The what bag? Oh, potato, yeah.
Every time they get a spare $3,500.
They have spare $3,500?
No, but
That's when Scotty gets a bonus from AP.
Tell me how that happens.
Scotty gets the bonus from AP. He makes me one summer.
I mean, why not? Anytime you go through life, spending your money should be fun. Is that okay? Yeah, you were number one. Thank you.
Yeah, just tell Ben because he asked me to. The other two people just voted the whole thing. Okay.
Test 1, 2, 3.
Give that man a raise. Thank you, sir. Appreciate that.
Checking levels back to the Senate recording studio. Mic check, 1, 2. Okay. You want me to get the thumbs up? Okay. John, they're gonna go. Yep.
You're worried it'll go down again? I guess so. Where is she? Sorry about the interruption there. Senator Tillis.
Oh, Senator,
Oh, your time's up.
thank you.
Senator Blumenthal.
Thank you, Mr. Chairman. That was almost the shortest questioning session you ever had.
I was getting ready to defend you and say, oh, no, it's Senator Blumenthal's turn.
Hard to keep track of us. I entered some letters into the record, Mr. Chairman, I believe, before we broke,
Yes, sir, without objection.
and I began my questioning about the Third Circuit opinion in Binderup. I believe that you would agree that decision applied to misdemeanor
Yes.
offenses, correct? Not to
Yes.
felons.
Yes, I was thinking of the separate opinion that Judge Hardiman wrote, I think for 5, and it was a splintered decision, but the holding, I agree.
So it
is
really doesn't
misdemeanors.
support the dissent that you wrote in,
Judge Hardiman's position does for the 5, but you're right, I had misremembered the common judgment holding for the plurality.
thank you. I want to ask you also, or clarify, the quote that I read to you was from a speech that you gave to the Hillsdale College, May 21, 2019, and it was, quote, about your opinion, dissenting opinion in Cantor, quote, "It sounds kind of radical to say felons can have firearms," end quote. So I just want to clarify, that was the source of the quote
Yes.
that I read
I
to
too
you.
had- Thank you. I too had looked at that because I was pretty sure I hadn't written the opinion. So I think, yes, it was in the course of explaining the opinion to that audience. I was saying it sounds kind of radical, but then going on to explain why it wasn't and the reasoning. But yes, thank you for correcting that, Senator.
Thank you. I also want to go back to another aspect of our conversation because Senator Graham asked about it this morning. I showed you a letter that you signed from 2013 by the Notre Dame Faculty for Life, and specifically a sentence, the unborn to be protected. We renew our call for the unborn to be protected in law and welcomed in life. And then I asked you about the IVF procedure, whether it could be banned criminally under the Constitution. And you said to me that you couldn't answer that question in the abstract. You said, we can't answer questions in the abstract. I asked you about your legal opinion and position, not your personal beliefs or religious views. You understand that point?
Yes, yes.
And I am disappointed that evidently you can't tell us or the American people whether you believe or your legal position is that IVF can be constitutionally banned, because so many Americans depend on this medical procedure for the ability to have children. I also want to ask you, should courts, specifically the Supreme Court, be deciding the next presidential election?
So the presidential election, as with all elections, is a matter put to the voters to cast ballots.
But the presumption should be against the courts deciding an election. It's the people and the voters who should decide, correct?
Let's see, Senator Blumenthal. So I think that occasions on which courts adjudicate election disputes are designed to protect the voter's choice and the right to vote. So of course, the Supreme Court doesn't cast ballots. Voters cast ballots, and election law is designed to protect the right to vote.
The courts should do everything possible to avoid embroiling themselves in elected politics.
Russo versus Common Cause says that, for example, gerrymandering is a political question because it's difficult in many circumstances for courts to develop judicially manageable standards to.
Presumption should be against courts getting involved. Let me ask you about some precedents, and I'm asking not about super precedents.
Okay.
And as you define super precedents, they are cases so well settled that no political actions, no people seriously push for their overturning. I'm not asking you about what other people may think about these cases, or may do about them. And I'm not asking you hypotheticals. These are real cases. First, Brown versus Board of Education. Do you think it was correctly decided? I know you told Senator Graham you thought so. I'd like you just to clarify that point.
Sure. So as I said to Senator Graham when he asked me that question, I have spoken on that before in the originalism lecture that I give.
As you
students,
sit
and said
here,
yes. And
correctly decided, right?
correctly decided, and yes, I've said that.
Thank you. Let me ask you about Loving versus the Loving case. Do you think that was correctly decided?
Well, Loving follows directly from Brown. Brown is correctly decided, Loving as well.
It was correctly decided.
It was correctly decided.
Thank you. Now let's talk about Griswold. Correctly decided?
Well, Senator Blumenthal, the reason
I know you
why-
gave an answer, excuse me for interrupting.
Yes.
I know you gave an answer to Senator Coons, but this issue is more than academic. That was the word that you used. You said that it's very, 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 very unlikely to be challenged, and maybe, but all the more reason that you should be willing to tell the American people it was correctly decided. I'm asking about your legal position. Would you have been in the majority?
Well, Senator, I have a couple of things on that. One is that the reason why I expressed a view on Brown to Senator Graham is that I do think what I have said in print, either in my scholarly work or in judicial opinions, is fair game. And I have expressly said in the past, in the originalism lecture that I've given repeatedly, that Brown was correctly decided. So I think that was fair game, and Loving is indistinguishable from Brown. It flows directly from it.
Loving
Not
involved
open-
interracial marriage, and Griswold involves a ban on contraception, criminal ban on the use of contraceptives, which in turn also involves Eisenstadt v. Baird. These are fundamental cases, and I'm asking your legal position. I want you to keep in mind how many people are listening and watching because they may take a message from what you say. They may see what you say and be deterred from using contraceptives, or may feel the fear that it could be banned.
Well, Senator Blumenthal, the position that I've taken is whether a question is easy or hard, that I can't offer an answer to it. And I would be surprised if people were afraid that birth control was about to be criminalized, because I said to Senator Coons.
You
I
may
don't
be
see any-
surprised, but Chief Justice Roberts said, quote, "I agree with the Griswold Court's conclusion that marital privacy extends to contraception. Justice Kennedy, if a hypothetical case were to be imagined that better fits within the privacy that I believe the Constitution protects, I couldn't think of a hypothetical better than Griswold." At his hearing, Justice Thomas said, "I believe the approach that Justice Harlan took in Poe v. Ullman and reaffirmed again in Griswold in determining the right to privacy was the appropriate way to go." And he reaffirmed Eisenstadt v. Baird. I'm stunned that you're not willing to say an unequivocal yes, it was correctly decided, I would have been in the majority. Lawrence v. Texas, which held that the government cannot criminalize gay and lesbian relationships. Was it correctly decided?
Senator Blumenthal, I've said throughout the hearing that I can't grade precedent, in the words of Justice Kagan, give it a thumbs up or a thumbs down.
So you can't
and
give
it
me
does-
a yes or no answer. Again, forgive me for interrupting, but my time is limited.
Well, Senator Blumenthal, I can't give a yes or a no, and my declining to give an answer doesn't suggest disagreement or agreement. And it certainly shouldn't suggest that.
I'm asking your legal position, Judge, not your moral position, not a policy position, not a religious faith position, a legal position. Correctly decided, Obergefell versus Hodges.
Senator Blumenthal, every time you ask me a question about whether a case was correctly decided or not, I cannot answer that question because I cannot suggest agreement or disagreement with precedents of the Supreme Court. All of those precedents bind me now as a Seventh Circuit judge, and were I to be confirmed, I would be responsible for applying the law of stare decisis to all of them.
But, Your Honor, think of how you would feel as a gay or lesbian American to hear that you can't answer whether the government can make it a crime for them to have that relationship, whether the government can enable people who are happily married to continue that relationship.
Senator,
Think of how you would feel.
Well, Senator, you're implying that I'm poised to say that I want to cast a vote to overrule Obergefell, and I assure you, I don't have any agenda, and I'm not even expressing a view in disagreement of Obergefell. You're pushing me to try to violate the judicial canons of ethics and to offer advisory opinions, and I won't do that.
Judge, you yourself wrote in 2016 an article that you co-wrote with John Nagel. It's called Congressional Originalism. Quote, a confirmation hearing answering hypothetical questions about the soundness of particular precedents is par for the course, end quote. It is par for the course because Americans want to know your legal positions on these issues, and they have a right to know. They deserve and need to know. And I am surprised, and I think a lot of Americans will be scared by the idea that people who want to simply marry or have a relationship with the person they love could find it criminalized, could find marriage equality cut back. I think it would be an America where I wouldn't want to live.
Well, Senator, to suggest that that's the kind of America I want to create isn't based in any facts in my record. And that quote that you read to me from the article talked about it being par for the course for those questions to be asked, but didn't say anything about whether it was appropriate for nominees to answer them.
Others have answered that same question, and I'm disappointed that you won't. Let me move on to another area. Last month, the New York Times published a series of bombshell reports dealing with the current state of the president's finances. There were a lot of revelations in that report, including that the president himself is responsible for loans totaling $421 million, most of which is coming due within 4 years. That amount of personal debt makes the president vulnerable to leverage, to manipulation, to coercion. His vulnerability makes him a threat to our national security. I'm not going to ask you about that aspect of his finances, or that he paid only $750 in income taxes in 2016 and 2017. I want to ask you about a fact that is critical constitutionally. During his first 2 years in office, the president received $73 million from foreign sources. Now, in the interest of full disclosure, I just want to say I led a lawsuit involving 200 of my colleagues challenging the president's receipt of those foreign benefits and foreign payments as a violation of the Emoluments Clause. And we cited as well other payments and benefits that he received from India, Afghanistan, Kuwait, Qatar, Malaysia, Saudi Arabia, Slovakia, and Thailand, and more, in violation of the Emoluments Clause. And we've been talking a lot about originalism. The Emoluments Clause was the premier anti-corruption clause in the United States Constitution. As Edmund Randolph of Virginia said, specifically, the clause was intended to, quote, prevent corruption, end quote, by, quote, prohibiting anyone in office from receiving or holding any emoluments from foreign states, end quote. The lawsuit that I led was denied certiorari yesterday by the United States Supreme Court. The DC Circuit Court of Appeals ruled against us on the limited technical issue of standing. It didn't deal with the merits. I hope that you will keep in mind the danger of corruption and the need to give citizens standing to enforce laws that prohibit corruption. Nobody is above the law. You've stated that position very well. And enforcement of laws that prevent corruption is vital. And my view is that the president, any president, must be held accountable. Do you agree?
No man is above the law. I agree with that, as I've stated very clearly before. And I also want to assure you, Senator Blumenthal, that I will apply all laws and come to an open mind with all laws, including laws dealing with anti-corruption.
Let me ask you about a topic that really hasn't arisen much here.
Okay.
Climate change. One of my colleagues, Senator Kennedy, asked you about it late in the hearing yesterday. And your answer was, quote, "You know, I'm not a scientist. I have read things about climate change. I would not say I have firm views on it." Do you believe that human beings cause global warming?
Well, Senator Blumenthal, I don't think I am competent to opine on what causes global warming or not. So I
Well, we all have
really
views on it.
offer-
I'm
Yeah,
asking
but
for your opinion.
I don't think that my views on global warming or climate change are relevant to the job I would do as a judge, nor do I feel like I have views that are informed enough, and I haven't studied scientific data. I'm not really in a position to offer any kind of informed opinion on what I think causes.
I understand.
Global.
And again, I apologize for interrupting. Do you agree with the president on his views of climate change?
I don't know that I have seen the president's expression of his views on climate change.
Okay. Let me ask you on another area. Are you aware of the Supreme Court, as it's called, shadow docket?
I am.
Essentially, this docket consists of cases that are decided, often stays or extension of orders, without an opinion, correct?
Correct.
And as a matter of fact, in the denial of certiorari in Blumenthal versus Trump yesterday, there was no opinion providing the reasons why they did so. We don't even know how many justices supported the decision, except that there must have been at least 5. And despite detailed reasoning from lower courts, which we challenge, about the issues, there was no opinion. And the same was true of the census decision, as you know. So don't you think there should be transparency on the part of the Supreme Court?
I think that the court, in the practice of denying cert petitions routinely, and you know, the shadow docket has become a hot topic in the last couple of years, but you know, even when I was clerking on the court in 1998, it was not typical for the court to issue opinions explaining why cert was denied, although sometimes there are dissents from the denial of certiorari which have opinions. But as far as I know, it's never been the routine practice of the court to have opinions.
My time is limited, but I just want to leave you with the very strong message, because increasingly the court has turned to this shadow docket. In fact, it's growing larger. It's up to 6,000 cases every year where it rules without an opinion and without disclosing who voted which way. That strikes me as anti-democratic with a small d. It decides only about 80 cases on its merits docket every year, which is smaller than when I was a law clerk on the court, and probably when you were a law clerk as well. So fewer cases, accountable, and less transparency. I am going to conclude here. I just want to say we tried to bring into this room real people who are going to be affected by your decisions. Some of them will lose their coverage. In fact, millions of Americans, including Connor Curran, will lose his coverage under the Affordable Care Act if he's denied the protection to people with pre-existing conditions. Legislative activism from the bench and the kind of activism that I fear you will bring to the bench is one
Judge Barrett, thank you again. 4 cases: U.S. versus Lopez, D.C. versus Heller, Hobby Lobby versus Burwell, Washington versus Glucksberg. Were they correctly decided? Got to put your mic on.
Is it working now?
Yeah.
Okay, good. Senator Tillis, I can't express a view on the correctness of any precedent.
So I think it's pretty clear that it's not just cases favored by my Democratic friends. You're taking a very consistent position, and I think the American people should understand that. Thank you. I had a sheriff in Wake County. In North Carolina, you have to apply for a permit to purchase a handgun in North Carolina. And for a period of time, the sheriff of Wake County refused to process handgun permits. He has subsequently reversed that policy, so it's no longer an active case. But, you know, it would seem to me that that sheriff was making a decision that wades into, I think, a Second Amendment right. How would you evaluate a case like that if it came before you?
So if a case like that matured into litigation and went up the appellate process, I mean, I would look at the law, and obviously the Second Amendment would be relevant there. So I would, read all applicable precedents, including Heller, to determine whether what the sheriff had done violated the Second Amendment right or not.
Well, I think in that case it did, but I would leave it to somebody far more qualified than you to take it forward. And I suspect it will if the sheriff reimposes the same imposition on lawful gun owners. I thought about this when Senator Hawley was asking a similar question. I've finished my 68th telephone town hall since the first case was reported in North Carolina. And about a month into it, everybody understood that we had to shut things down, try to understand how COVID was affecting us. But then about 4 to 6 weeks later, we saw peaceful protests, some of which were hijacked, and we've seen them widely reported, allowed by certain liberal governors and other elected officials in towns and counties. But at the same time, they prevented churches from being able to worship. You enumerated the protections, the specific protections under the First Amendment, and I think religion and protest are 2 of them. Do you feel like any governmental entity has a right, on the one hand, to allow these protests to occur, and on the other hand, prevent worship in temples, synagogues, mosques, or any place of worship?
Well, Senator, those kinds of cases are being litigated all around the country right now. Some have gone up to the Supreme Court on a couple of different orders, so those aren't things that I would be able to comment on.
Are you able to opine at all on how you would go about evaluating the arguments?
Sure. So whenever you have that kind of a restriction, like, as we are in a pandemic, the Supreme Court's general position is that the government has a compelling interest in responding to a health crisis of this sort. So you look at the case law describing the extent of the state's authority to address a public health crisis. It's come up before in a case involving vaccination. Then you also, and this was clear in my interchange with Senator Hawley, you also look at the other amendments and other rights at play. So in the case that I had, it involved the First Amendment, looking at the speech and free exercise clauses of that amendment. So those come into play as well.
Thank you. When I met a couple of weeks ago, I have to thank you again. My daughter was thrilled that you signed the 2 pocket constitutions for my 2 granddaughters, and they'll cherish it someday when I can explain what it really means. It's going to take a few more years. One is 3 and the other one's 8 weeks. But I really enjoyed that discussion. And I ask you there something I'd like for you to share with the committee. You have stellar academic credentials. You have stellar record as a professor, and you've done an excellent job on the 7th Circuit. You've been a great mother and wife. You have so many options. There are so many things that you could be doing besides going through the first confirmation hearing, which was not pleasant. I was here and I remember it. And you knew that this was even going to be more challenging. So I asked you when we met, why would you do this? Knowing how this was going to play out, knowing that you were going to be attacked and unfairly treated. And I think to a level of maybe where some of your constitutional rights have been questionably denied. So why are you doing this, Judge Barrett? Why not just say thanks but no thanks, leave it for somebody else?
Well, as I said to Senator Graham yesterday, and I think this was part, and parcel of the conversation that you and I had, that this is a very difficult process. Actually, I think I would use the word excruciating over the weeks, and the knowledge that, people are going to say horrible things, that your entire life will be combed over, that you'll be mocked, that your children will be attacked. And so one might wonder why any sane person would undertake that risk and that task unless it was for the sake of something good. And as I said yesterday to Senator Graham, I do think the rule of law and its importance in the United States, and I do think the role of the Supreme Court is important. It's a great good. It would be difficult for anybody in this seat. I think everybody knows the confirmation process is very difficult. And so for me to say no, other people could do this job, but the same difficulty will be present for everyone. And so for me to say, I'm not willing to undertake it, even though I think this is something important, would be, a little cowardly. And, I wouldn't be answering a call to serve my country in the way that I was asked. I also think in our conversation, I said, that my children were part of the reason not to do it because, my son Liam got very upset yesterday during the questioning. And so, we had to call him in the car. He didn't stick it out to the end. I was surprised he stuck it out as long as he did. But Liam got very upset at the questioning, and Senator Kennedy referenced some of the other things that have happened to the children in the process. And so I said to you before any of that happened that in many ways the children are the reason not to do it, but they're also the reason to do it, because if we are to protect our institutions and protect the freedoms and protect the rule of law that's the basis for the society and the freedom that we all enjoy, if we want that for our children and our children's children, then we need to participate in that work.
Well, I think you're an extraordinary role model to a lot of people watching. I agree with Senator Blumenthal. A lot of people are watching this, and I hope that every one of them conclude that you're a courageous person and you're a public servant. With your credentials and your experience, you could move out of public service and do virtually anything you wanted to and have more time with your family along the way. And the fact that you're willing to serve is just, I think, an extraordinary testament to your character and your integrity, and I appreciate you for it. The other thing I wanted to get back to is on the issue of abortion. I think it's remarkable over the course of the past couple of days how many times they have, my colleagues on the other side of the aisle have challenged you on this matter. And in the same breath, they're advocating for activism. In one breath, they want to secure certain Supreme Court precedent. On the other breath, they want your commitment to potentially overturn it. But I want to talk specifically about a policy in Gonzalez versus Carhart. I mentioned yesterday late-term abortions, partial birth abortions. I've thought were horrific all of my life, but especially since I held that premature granddaughter of mine who was born 3 weeks premature. How would you, if a case as a matter of state law or federal law, let's say Senator Graham's bill, how would you go about evaluating maybe some laws that would prevent late-term abortions, partial birth abortions? How would you go about evaluating that in light of Gonzalez versus Carhart?
Well, I would look at all the precedents. Casey, as we discussed yesterday, sets out the undue burden standard, which is the test, and then Gonzalez versus Carhart, as you say, upheld a restriction on partial birth abortion. Whole Women's Health and June Medical are the most recent cases in the abortion line. So if I were to have to decide a case involving a bill like the one that Senator Graham has referred to, it would involve looking at all of those precedents and their application to the particular contours of the law that was before me.
Thank you. Now I'm going to go in a slightly different direction. I was talking with Senator Coons, who is the ranking member on a committee that I chair, a subcommittee here on intellectual property. we've done a lot of work, and we're working on a bipartisan, bicameral basis. And I have to thank Senator Blumenthal for probably being one of the more active members in this committee. I think it's an area where we really are working on a bipartisan basis, the things that the public seldom see. But I want to ask you first on antitrust. I know a district court opinion sided with Federal Trade Commission that found that Qualcomm violated antitrust law. And the Ninth Circuit overruled that district court decision. I don't know if you followed it, but in the Ninth Court opinion, they said that Qualcomm was a company just asserting its economic muscle with vigor, imagination, devotion, and ingenuity. I know you can't speak to that case, but I'm interested in your thoughts generally on antitrust law. Where do you think the court should draw the line on federal antitrust limits between where a company violates an antitrust law or, as Qualcomm was characterized, of just asserting its economic muscle with vigor, imagination, devotion, and ingenuity?
I haven't followed that case, so I'm not aware of that case from the Ninth Circuit, but I would be venturing out into that hypothetical dangerous territory if I tried to articulate what hypothetical line to draw in the context of antitrust law, because, well, as you probably know better than I, just being on the committee, it's a complex area with lots and lots of precedent and lots of statutory and regulatory law as well.
Moving to another area that's been addressed on the Committee on Intellectual Property and Patent Law Eligibility. As judge, I should say, as chairman of the subcommittee, I'm really interested in protecting the intellectual property of the American innovation economy. There's no question that we're the leader in the world. But in recent years, we've seen a lot of Supreme Court cases that have waded into patent eligibility, producing a series of opinions that have really muddled the waters. And in some cases, I think that I agree with the decision, but I worry about the methodology that they use to get there. So I'm curious about your thoughts. In my committee, we've talked about specific cases that we could potentially abrogate if we could get bipartisan support, and we're in those discussions. But what are your thoughts on the Supreme Court's rulings on patent eligibility? And do you think that the court should go back and clarify at least the method that they use to reach their opinion?
So without commenting on any particular cases, which actually I have to be completely honest and confess to you, I can't think of what particular cases you might be thinking of in the patent eligibility, but without commenting on those cases in any event, I think I would say that clarity in decision-making is always something that courts should strive for, and I know on the Seventh Circuit, we try, and I'm trying to be attuned to in writing opinions, whether it gives good guidance to lower courts and then to also those who are trying to order their conduct, in compliance with the law. So I think clarity is certainly a virtue in this context.
And I think that we're working, like I said, on a bipartisan, bicameral basis to help or do it on our part. Copyright law and technology is another area that we focus quite a bit on. I think I had one witness say that our current laws are MySpace laws in a TikTok world. There's a lot of changes that have occurred, and we feel like there's a need for us to maybe move forward with some clarity and some protections. The Supreme Court has spent more than a century answering questions about whether copyright law covers new technologies like cameras, player pianos, moving pictures, the list goes on, several internet-enabled technologies. Do you think that the Supreme Court is the best institution to answer these questions, or is that a role Congress should play?
Most of the things you're identifying sound to me like matters of policy, and so those seem like matters that are best addressed by the legislature, a democratically elected body, not policy made by courts.
I agree. I think it's a complex subject, and I'm glad to hear your opinion, and I hope that we make progress on it. And again, I have to thank Senator Coons and Senator Blumenthal and Senator Hirono, who are on that subcommittee, I think we've worked well, and I'm hopeful that we'll make progress. I think Senator Blumenthal asked you about the courts getting involved in elections, but before somebody goes out into the cyber world and says 9 people are going to decide the outcome of the election, 9 votes versus the tens of millions of votes that are being cast now will be cast by November the 3rd. What you're potentially going to be confronted with are various lawsuits that may come in based on changes in voting protocols for this cycle versus other ones. But at the end of the day, what role is the court going to play, if any, in the determination? 9 people are not going to elect the president, regardless of who wins the election. But 9 people are going to have to consider various cases. But at the foundation, is it accurate to say that your role will be determining whether or not every single American who wishes to vote had their vote recorded and was given proper access to make that vote? Is that fundamentally what the courts would decide?
Fundamentally, if an election dispute arose, obviously the issue, it's impossible to predict what particular aspect of the election would be challenged. But the laws that would be invoked are laws that protect the right to vote, that keep elections fair. So those are the kinds of issues that have come up in past election disputes. And so certainly the court would not see itself as, and would not be electing the president. It would be applying laws that are designed to protect elections and protect the right to vote.
I also want to thank you in closing, Mr. Chairman. I want to thank you for reaffirming, I think in a discussion with Senator Durbin, possibly Senator Hawley, that you believe every single person in this country should have a right to vote, and that they should be able to do that without intimidation, without any undue burdens. And I appreciate you reaffirming that. And I just want to make sure I heard you right in your responses to other questions. You do feel very strongly that every American should have safe access to the vote. And I, for one, hope that every registered voter in this country vote on November 11th. That may be a stretch goal, but do you agree with that?
Of course, yes.
Thank you, Judge Barrett, and thank you for your family for enduring all the challenges that you have. Thank you for your courage, and thank you for your integrity. I look forward to supporting your nomination.
Thank you, Senator.
Senator Hirono.
Thank you, Mr. Chairman. Today, we're going through this hearing as though it's a normal hearing, not a rush job in the midst of a pandemic, 200,000 Americans dead, no pandemic relief bill in sight for the American people, the fate of the ACA at risk. But the Democrats on this committee have asked and will continue to ask you questions to let the American people know that your being put on the Supreme Court will dramatically flip the balance of power to the court, further to the right, not the fair, impartial body we want the Supreme Court to be. Judge Barrett, yesterday you told Ranking Member Feinstein, quote, if there were policy differences or policy consequences, those are for this body. For the court, it's really a question of adhering to the law and going where the law leads and leaving the policy decisions up to you. That would be us in Congress. The effects of this distinction you made between law and policy, a distinction I described yesterday as artificial, can be seen in a case from earlier this year. In Cook County v. Wolf, you considered the Trump administration's dramatic change to the public charge definition, a wealth test to prevent low-income immigrants from entering the United States or becoming permanent residents. The majority found the rule had, quote, numerous unexplained serious flaws and barred its imposition. You, on the other hand, issued a 40-page dissent calling the rule reasonable. You would have allowed the Trump administration to limit low-income immigrants who might become a public charge. You call this rule reasonable despite the harm you knew it would inflict. For example, Illinois has approximately 3.1 million people enrolled in Medicaid, including 388,000 non-citizens and 341,000 citizen children with an immigrant parent. It estimates over 140,000 individuals will disenroll from benefits and public services as a result of the public charge rule. Nationally, about 1 to 3 million people have disenrolled or gone without Medicaid coverage due to fear of consequences from the application of the rule to them. Dana, a community service provider in Colorado, can tell you about a single mother who didn't want to enroll her autistic U.S. citizen child in necessary health and education services. Dana can also tell you about a pregnant woman in her 3rd trimester who sacrificed prenatal care. The effect of the public charge rule has intensified as people forego testing and treatment for COVID-19, ensuring people will be sicker, more likely to die, and more likely to inadvertently spread the virus. Sarah, who helps provide legal assistance in New York, works to lessen the devastating, impact of the rule. This includes working with one immigrant living in a shelter seriously ill with COVID-19 symptoms and unwilling to get tested or treated out of fear for her status. And while the Trump administration admitted the rule's connection to a reduction in public benefit enrollment and food insecurity, housing scarcity, and increased costs for states and localities, it brushed off the impacts and refused to alter the rule. Similarly, in your dissent, you also acknowledged that people are disenrolling from health and other programs out of fear. You not only admitted to the disenrollments, you found it unsurprising. Disenrollments reportedly affect nearly one-third of all low-income immigrant families with children. Judge Barrett, just to be clear, do you believe these disenrollments are policy consequences that are the job of Congress to fix, not the courts to consider?
Senator Hirono, the dissent that I wrote in Cook County went through the public charge rule and the statute to explain that those who are currently receiving benefits were not affected by the public charge rule. It was a prospective screen. But I agree with...
Excuse me, Judge Barrett. I read your dissent, and I know you went through the laborious, you tried to show the people who would actually be impacted by the rule, but in your dissent, you also acknowledge that there are a lot of people who are not impacted by this rule who will disenroll because of fear that the rule would apply to them.
What I
So
said
my
was that
question
it
to
was
you
fear-
is whether those kinds of effects, which you foresaw, you even acknowledged it, if you think it's appropriate for the court to consider those effects.
So Senator Hirono, as I was trying to answer before, yes, I said that there was fear and there was disenrollment, but that in fact the rule did not apply to anyone who is currently eligible for benefits. The question of disenrollment and the effects of the rule would be relevant at the stage of arbitrary and capricious review. I was just saying the first step, which was the interpretation of the statute, but I said that I wouldn't reach the question in that case because it hadn't been briefed. So what I said in my dissent was that it would be better to send that back to the district court for briefing on the question of whether the rule and the evidence that the agency had gathered was arbitrary and capricious, including its treatment of the costs for state and local governments, et cetera.
Judge Barrett, you deem the rule to be reasonable, so I take it you stand by your dissent in that
I
case.
stand by my dissent, but Senator Hirono, there is a difference between reasonable under the Chevron doctrine and arbitrary and capricious under the Administrative Procedure Act. So just what I'm clarifying is I did not.
But as you noted in your dissent, the APA was not even brought up, so that was not an issue. So everyone seems to agree that this rule is having a chilling effect nationwide among families, affecting access to health care, nutrition, food, housing, benefits that Congress meant to make available. So I would say that from from your response and the response you gave to Senator Feinstein about the distinction you make between policy and law, it seems to me that in this case, you did not give much credence to the effect of this rule.
It wasn't.
Albeit the rule did not apply.
It would have been the question at the arbitrary and capricious stage because that's one of the relevant factors. But, you know, the laborious study that I did in the public charge case responded to the arguments the parties made and the complex statutes that Congress has passed in this area, including the welfare reform.
Judge Barrett.
Yes?
I'm sorry too, I don't think you even mentioned arbitrary and capricious standard. So let me move on. Yesterday, Senator Graham asked you about how unlikely it would be to overturn Supreme Court precedent on a range of issues. And you said, quote, "Judges can't just wake up one day and say, I have an agenda. I like guns. I hate guns. I like abortion. I hate abortion," and walk in like a royal queen and impose, their will on the world. You have to wait for cases and controversies. But I don't think that's an entirely accurate picture, because certain justices have been using their opinions to signal interest in addressing various issues, particularly those undermining workers' rights, civil rights, even inviting challenges to longstanding precedent. In fact, as Senator Whitehouse explained this morning, just 2 years ago, the Supreme Court overturned a 41-year-old precedent. Talk about reliance on a precedent. This precedent was called Abood, which protected public sector unions, and Justice Alito engaged in a six-year campaign. And I just have this chart to show you that he was very persistent in signaling that he wanted to revisit Abood. So in 2012, Justice Alito first signaled that he wanted conservative anti-union groups to challenge Abood in his decision in Knox v. SEIU. These groups brought case after case to meet the criteria Justice Alito laid out. Although they came close in 2016, his plan was thwarted by Justice Scalia's death, which left the court stuck in a 4-4 decision, tie, and Fredericks. Justice Alito had to wait until Senator Mitch McConnell blocked Merrick Garland's nomination for nearly a year as President Trump, so that President Trump could appoint Neil Gorsuch. Pretty much the minute Justice Gorsuch got on the court finally overturned Abood in Janus. Now we're seeing that same kind of signaling to invite challenges to another precedent. I mentioned this yesterday, Obergefell, which recognized the right of same-sex couples to marry. And last week, the court denied review in over 1,000 cases, but Justice Thomas with Justice Alito issued a sharply worded statement about one case that was denied review, Davis v. Ermold. And that case involved a former Kentucky clerk who refused to issue marriage licenses to same-sex couples after Obergefell. So like Justice Alito in 2012, Justice Thomas, joined by Justice Alito, signaled an eagerness to roll back a Supreme Court precedent that they believed conflicted with their understanding of the Constitution. They criticized Obergefell for, quote, reading a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text, and called it a problem that only the court can fix. Judge Barrett, you said judges have to wait for cases and can't say, I have an agenda. But here you have examples of justices who are sending out signals. Bring these cases to us because we want to take a look at precedent. I just want to cite one case where I think that you are also sending out a signal, and that is a circuit court case. Well, two circuit court cases. One that has you've been asked about, Cantor v. Barr, where you wrote a dissent arguing that certain people with felony convictions should have the right to have a gun, and you went out of your way to raise the issue of whether their right to vote, about their right to vote, and raising concerns that you view their right to vote to be more limited than their right to own a gun. In another example, in Price v. City of Chicago, in that case, you joined a decision that upheld the so-called abortion clinic buffer zone law. As a circuit court judge, you had to apply the law under clear Supreme Court precedent. But the decision that you joined went even further. It signaled a strong disagreement with that precedent, the Supreme Court precedent, calling it, quote, incompatible with the First Amendment and imposing serious burdens, and directed the plaintiffs to seek relief in the Supreme Court. You are going to be, if confirmed, on that Supreme Court. Earlier today, Senator Coons showed you a chart of more than 100 cases where Justice Ginsburg was in the majority and Justice Scalia was in the dissent. And the chart showed the many rights at stake, including longstanding precedent with your nomination. And that includes workers' rights, civil rights, healthcare, campaign finance limits, and environmental protections. My Republican colleagues are well aware of this, and that's why they want you to be on the Supreme Court so badly. In 2016, after Justice Scalia died, you described him in a TV interview as the staunchest conservative on the court. Is that correct?
I can imagine that I said that as I'm sitting here. I can't recall my exact words.
Well, I'm quoting you, so
Okay.
yes, you said that. And you also recognize that replacing the staunchest conservative on the court with someone nominated by President Obama could dramatically flip the balance of power in the court. That's a quote from you. Could dramatically flip the balance of power in the court. You are now in a position that you described 4 years ago of dramatically flipping the power of the court. So your nomination would actually be more dramatic, a more dramatic shift. Law professors such as Professor Stephen Vladeck have pointed out that with your confirmation, the court would be transformed into the most conservative court since the 1930s, with a much more aggressive conservative agenda. In accepting your nomination, you described Justice Scalia as your mentor. That's been mentioned many times before. It appears that you may be even more to the right of Justice Scalia, whom you described as the staunchest conservative. I think it's important to look at what kind of impact you would have had on more recent Supreme Court decisions. When Justice Ginsburg served on the court, the Roberts Court issued numerous 5-4 partisan decisions. But what's notable are the more recent 5-4 decisions after Justice Kennedy, who was often in the middle of the ideological spectrum, was replaced by a much more conservative justice. The court shifted rightward as Chief Justice Roberts' conservative views was now in the middle of the ideological spectrum of the court. So, Judge Barrett, are you familiar with the recent 5-4 decisions where Chief Justice Roberts joined the 4 liberal justices to form a majority?
What
I
decisions
have a
are you
chart
referring
for
to?
that. Are you familiar?
I don't know what decisions you're referring to.
There are a number of them. I would just touch on 2, and I'll describe them. So these 5-4 cases touched on several issues that highlight what's at stake with your nomination. These issues include protections for Daca recipients, the integrity of the census, reproductive rights, digital privacy rights, right of criminal defendants, COVID-19 safety measures, protecting agency regulations, covers a wide range of protections from veterans' benefits to clean air and water. I'm just going to go to the Daca decision that I mentioned in June 2020. Justice Ginsburg was part of a 5-4 majority with Chief Justice Roberts that blocked the Trump administration's efforts to end the Daca program. And replacing Justice Ginsburg with a conservative like Justice Scalia would have thrown the lives of 800,000 Daca recipients and their families into chaos. The Daca participants would be facing deportation. That includes the over 200,000 Daca recipients who are risking their lives on the front lines of the pandemic to protect the health and safety of us. And last year, Justice Ginsburg and Chief Justice Roberts issued a 5-4 decision that blocked the Trump administration's anti-immigrant policy of adding a citizenship question to the 2020 census, something very near and dear to President Trump. And replacing, in that case, Justice Ginsburg with someone like your mentor, Justice Scalia, would have resulted in excluding many immigrant families from the census. That would not only have decreased their representation in Congress, it would also have decreased their share in the distribution of $1.5 trillion in federal resources. And yesterday, we saw what the court looks like without Justice Ginsburg on it. It allowed the Trump administration to end the census data collection early, despite the ongoing pandemic, despite the fact that they will not get an accurate census count by ending the data collection early. So of course that would mean probably fewer federal resources for communities where there is not that accurate count. That could also mean that Trump officials, instead of Census Bureau experts, may use the population numbers to determine representation in the House of Representatives and in state and local governments. And we already know that Trump is demanding that those numbers exclude undocumented immigrants, even if the census requires everyone to be counted regardless of immigration status. So President Trump has repeatedly accused Chief Justice Roberts of betraying conservatives in the court's decisions on health care, DACA protections, and other rights. He's made it clear he has nominated you to do the job he thinks Chief Justice Roberts and Republicans failed to do: strike down the Affordable Care Act and roll back critical rights and protections. You've already been asked about the consequences of the Shelby County decision. It was totally foreseeable that you would have a lot of states passing voter restriction, suppression, basically laws. Do you believe, Judge Barrett, that voter suppression or discrimination in voting currently exists?
Senator Hirono, we have the Voting Rights Act that offers protection, and Section 2 of the Voting Rights Act, which was not at issue in Shelby County, protects voters from any kind of measures that would discriminate on the basis of race, and so that gives protection.
Do you think that the Justice Department is pursuing aggressively those sections of the law? Because we know that over a dozen states passed what I would characterize as voter suppression laws. So that is obviously happening. Now, in that case, Justice Thomas went even further, because the majority in Shelby County left the framework for allowing Congress to come back with formulas that would enable preclearance to occur. But Justice Thomas went even further. He said, get rid of the entire framework. Congress, you're totally out of the picture. So this is the danger we're facing with your being put on the court. One more thing. I have just one more question. Do you think that having 3 justices who have worked on the Republican side, Bush v. Gore, you're one of those justices, should you be confirmed, creates an appearance of conflict if an election case involving a president who nominated you comes before the court? And I'm basically out of time, so I'd like a yes or no answer.
Well, Senator Hirono, I answered that question before and said any question of whether there was an appearance of partiality problem would be one for all justices involved to consider under the recusal statute.
So you think there might be a conflict, and therefore you would have to go through that entire
Senator,
process?
I think anytime someone makes a motion to recuse, and indeed even one is not made, a judge always has to consider that issue. So, I mean, you're asking me to make a decision about whether I think myself and 2 people who are not even yet my colleagues should recuse in that situation, and I'm just saying that
No, but actually, my question was whether it poses an appearance of conflict, and I believe that the fact that you would even bring forth the recusal process says to me that voters might decide that there is an appearance of conflict. Thank you, Mr. Chairman.
Thank you. Senator Ernst.
Yes, thank you, Judge Barrett, very much for being in front of us. Welcome to day 3. It's been quite a day, and because we do have so many members that have been busy talking over you and interrupting, and they've said so themselves. Pardon me for interrupting you, telling me that their time is more important than hearing your answers. If you would like to take a few moments, if there's anything that you would like to further explain, I would welcome that at this time.
Thank you, Senator Ernst. I mean, I think the only thing I'd want to clarify is, insofar as Senator Hirono was suggesting, I think that the work that some of the justices may have done on Bush v. Gore is reason to recuse. That is certainly not what I meant. What I meant is that in every case, judges have an obligation to consider the issues, and they may conclude no. So what I meant to be saying was just not to take a position. So I just want to make that answer clear.
Right. I appreciate that. Thank you for taking that time. And Judge Barrett, obviously over the past number of weeks since you were nominated, and certainly since this hearing began, there's been a lot of discussion about the legacy of Ruth Bader Ginsburg, who was really a trailblazer. The Democrats seem to claim that you wouldn't be an adequate replacement for Justice Ginsburg because you do not march in lockstep with her judicial philosophy. The way I see it, you're both trailblazers and you're both accomplished professors. You were both respected and revered and had strong endorsements, both from the left and the right. And you're both amazing working moms. You both served in private practice. And like you, she was a woman of strong religious faith. And you both have a very impressive track record on the judicial bench. So asking women to march in lockstep with one philosophy is exactly the wrong kind of message we should be sending to women, and especially to young women. What I hear so often from the left, many of us on the right do, I would say probably Senator Blackburn hears this, many others hear this, that because we don't hold the same views that those on the left do, we shouldn't be serving in the roles that we are in. And that's what the left is projecting on you, is because you are not lockstep with what they want to see in their nominees, that you aren't worthy of serving on the bench. I don't believe that. I don't believe that. And that shouldn't be the litmus test for the Supreme Court. And frankly, it shouldn't be the litmus test for any woman in any job. Any woman in any job. Diversity of thought and an ability to pursue her dreams is exactly what the women trailblazers of the past fought for. If the suffragettes hadn't been willing to go against the men of their time, certainly none of the women sitting on this dais would have the opportunity to question you today. So what would you say to those that claim you are not an adequate replacement for Ruth Bader Ginsburg because you do not march in lockstep with her judicial philosophy?
Well, I think that judicial philosophy is an appropriate and an important topic for this committee to explore at the hearing. And I think each of the senators has a responsibility when a nominee comes before you to ask what the judicial philosophy is. And I think disagreeing with the judicial philosophy that I or any other nominee had is perfectly admissible grounds for voting no, because you may have a different vision for what a justice or a judge is to do. And so I have no problem with that. I mean, I think that is how the senators on this committee have viewed their role. And so to, on philosophical or, jurisprudential grounds, I mean, I think that's part of what, or, a lot of what this hearing should be about. I think that there's room on the court, and I don't think this just in terms of the women, but I think this for all members on the court, there's room for different approaches to the Constitution, and I think those approaches shouldn't be broken down into partisan boxes because judges are not partisan. They do get appointed and confirmed by the political branches, but judges don't have campaign platforms, and they no longer associate, as I've said a number of times through the hearing, judges stay out of politics. So their jurisprudential philosophies are not designed to yield particular results. So I think there's room for different jurisprudential philosophies that, by the way, even when they start and approach texts from different ways of thinking about it, sometimes yield the same result. It's not necessarily the case that two justices who, one being a pragmatist and one being an originalist won't end up at the same place. They just might get there a different way. Or even originalists, I mentioned yesterday that, there are many who identify themselves as progressive originalists. So originalists, could start at the same place, and, I suspect that, they would disagree, end up in different places, and I've given examples of that. So I think there's room, and it's good and healthy for different approaches to the Constitution and to have debates about that.
Thank you. I really do appreciate that answer. So as we've been sitting through these discussions, I've heard a number of my colleagues bring up different descriptive words to describe you, and I'd just like to review a few of those right now. Respect, intellect, character, jurisprudence, clarity, demeanor, humility, dignity, independent, exceptional. I think that you are exactly what we should embrace. And as I look at future generations of men and women that might want to serve on our Supreme Court, I hope that they would espouse those attributions as well. And while we have this national stage, I would like you, Judge Barrett, to share some grains of wisdom for those future generations. What advice would you offer to those who are just now embarking on their legal career? And how should they define success and find motivation to, kind of, quote, leave their best on the field, if you will, at the end of each day?
Well, I think, I loved the practice of law. Some professors go to the academy because they don't enjoy practice that much. I actually really, really enjoyed practice. And then when I went to the academy, I really enjoyed that too. I would say that, especially when you're beginning your legal career, often you're at an earlier stage in your life when you may have fewer other obligations or fewer family obligations and maybe more energy. So that it's, I guess I would just say, live life to the fullest, seize all of the opportunities you have and do your best. But at the same time, never let work crowd out all of the other precious things in your life, like friends and family and faith and exercise. I had a law professor who told first years who were very, very anxious and studying hard on exams to make sure that you gave yourself time to go take a run. Or go work out. I mean, I think all of those things that make up our lives apart from work, can't be shoved aside. At the same time, however, you should seize opportunities and pursue them while keeping in mind your whole person.
Yes, the whole person. Thank you. So when we sat down, Judge Barrett, I told you a little bit about my daughter, Libby, and she is studying pre-law right now. And she sent me a text this morning as we were in this room. And she said, I have to fisk an article on Judge Barrett. So we had this discussion of fisking a while back.
I don't know what
yes,
that is.
So I had to ask her what it was. And I actually Googled it to make sure I had the right definition. But fisking, the process of shredding a written argument line by line, parsing the meaning and providing counterpoints. So their instructor provided the class different articles about you, and they have to go through now and fisk the article. And she said, okay, so here's the whole text. I have to fisk an article on Judge Barrett, and honestly, what an amazing woman. So I just want to share that little bit of encouragement that while there may be others on this committee that disagree, I would share with you that there are thousands upon thousands of young women out there that see the role that you set. And I went through all of those descriptive words that my fellow members have shared through the course of these hearings, but those thousands and thousands of young women that see you as someone they can aspire to be. And I know that she is in a very diverse group of friends. They are racially different. They are religiously different, but they're all young warriors, all of these young women. But they are very excited to have you in front of us. I would say that many of her friends are not Republicans. They would affiliate more with Democrats as well, but they do see you as someone they can aspire to be. So thank you so much for setting such a great example for women of all different thought processes. And what words of encouragement would you like to share with the young women like my daughter, Libby?
I think I would say to be confident, to see what she wants, to have a plan. One thing I've often told my own daughters is, you know, that you shouldn't let life just happen to you or sweep you along. You should identify what your objectives are and identify the kind of person that you want to be, and then make deliberate decisions to make that happen. My dad used to tell us not to make a decision is to make a decision. So I would say make decisions, be
Wise.
confident, know what you want, and go get it.
That is fantastic. And, you know, I have 4 tenets that I live by, or pillars of success. And those 4 pillars are leadership, service, prudent risk, and gratitude. And so, I would like just to give you a couple minutes. You've already spoken to a few of those. You've talked about service and what it means to serve your nation. And you actually went through prudent risk in deciding to subject your family, your friends, yourself to this process, but deciding it was for the greater good. I'd like to give you just a moment to express some gratitude as well for those that have helped you get where you are today, and share maybe how they mentored you along the way.
Sure. Well, I mean, I think, as for probably so many people, my parents are the ones who I would have to express the most gratitude for, because, you know, they encouraged me at every step of the way. They've encouraged me and supported me and loved me and shaped me and given the values that I have. And then as I've had my own family and my own children, then they've helped me by supporting me with my children and reinforcing what they taught me. My professors in law school, we heard the other day from former Dean O'Hara, who was gracious enough to introduce me on the panel. I had so many wonderful professors when I was in law school. I had so many wonderful colleagues once I joined the faculty. When I was in practice, I had so many lawyers that I learned so much from. And then we've talked at great length about Judge Silberman and Justice Scalia, the judges for whom I worked. And so, you know, I guess village to raise a child. I think it takes a village to mentor anyone into who they become as an adult. And so I'm very grateful for the whole village that I've had that's brought me to this point.
Wonderful. Thank you very much, Judge Barrett.
Thank you. Senator Booker.
Mr. Chairman, thank you very much. Your Honor, hi.
Senator,
How are you?
I'm good. You?
I'm doing well. I'm doing well. I'm sure that part of that smile is the fact that I'm the second to last Democrat. I just want to jump right in because I actually found some of your responses to Senator Hirono are really compelling around the public charge issue, and that you dissented in the case. And if I could read it, you wrote that at the bottom, the plaintiff's objections reflect disagreement with the policy choice and even the statutory exclusion itself. Litigation is not the vehicle for resolving policy disputes, because I think the DHS's definition is a rational interpretation of the statutory term public charge. But you were saying to her, which I really found compelling, that you were still leaving the door open for it to be capricious. Was that the word you used?
Yes, so the standard of review under the Administrative Procedure Act would be arbitrary and capricious. So I said at the conclusion of the dissent, because the majority reached both, I said at the conclusion of the dissent that I wasn't resolving that issue because it hadn't been briefed before us, but I just wasn't expressing an opinion. I thought we needed a fuller record. So I did leave open the possibility that the rule would nonetheless be arbitrary and capricious.
Yeah, as I said to you on our phone conversation, trying to read all of your cases, it has been a Herculean task, as has probably yours, preparing for this so quickly. And so maybe I can just go back to asking just a simple question that I hope you'll feel comfortable asking. It's just what I think is an obvious answer again. But do you think it's wrong to separate children from their parents to deter immigrants from coming to the United States?
Well, Senator Booker, that's been a matter of policy debate, and obviously that's a matter of hot political debate in which I can't express a view or be drawn into as a judge.
So I respect that a lot, but I think the underlying question is actually not hotly debated. And just maybe I'll ask it one more time. Do you think it's wrong to separate a child from their parent, not for the safety of the child or parent, but to send a message? As a human being, do you believe that that's wrong?
Well, Senator, I think you're trying to engage me on the administration's border separation policies, and I can't express a view on that. So I'm not expressing assent or dissent with the morality of that position. I just can't be drawn into a debate about the administration's immigration policy.
Right. And of course, the question does have implications, but a very simple, as I said to you yesterday, that we're debating things that, to me, are basic questions of human rights, human decency, and human dignity. I'm sorry that we can't have a simple affirmation of what I think most Americans would agree on. But maybe I can jump back to something we began. Yesterday, I asked you whether you were familiar with studies conducted by the U.S. Sentencing Commission. Do you remember?
Yes, I said I was generally aware. Are you talking about when we talked about systemic or implicit bias and systemic racism?
Yes.
I'm generally aware that there have been studies done.
And so the U.S. Sentencing Commission provides non-binding federal guidelines to federal judges, which showed that some of the racial disparities in our criminal justice system, they talk about that considerably. And my colleagues and I on both sides of the aisle, as we worked on criminal justice reform, discussed a lot of them. And some of those, as I discussed yesterday, were examples that federal prosecutors are more likely to charge black defendants who carry, with offenses that carry harsh mandatory minimum sentences, they're more likely to charge black defendants than similarly situated white defendants. And black defendants were subject to 3 strikes laws, sentencing enhancements at a significantly higher rate than white defendants, which on average actually added 10 years to their sentence, a significant surrender or seizing of liberty. And you said you were not familiar with that particular study, as you just reaffirmed, or the facts that they cite in the study showing that interracial bias is present in our system. And you know, I think in our discussion, I think it came out that you know that these issues of bias in our criminal justice system are manifest really in many different aspects of the system, from police misconduct, unlawful use of force, to prosecutorial bias, sentencing disparities. These are wide and vast areas that have been shown to have such implicit racial bias evident in them. And this year, clearly, we've been grappling as a nation with a lot of these issues. And it is a part of our long-standing history. You cannot divorce the role of judges in our history over these some 200 years and how race has been a persistent part of the national narrative, grappling with deep issues of bigotry and bias, overt as well as the biases that exist. We know that many of the unjust deaths of unarmed African Americans at the hands of law enforcement have brought this even more into public concern. And so I just want to ask you, and maybe give you more of a chance to discuss. I understand that you weren't aware of specific studies I cited, which are central to the important work of the U.S. Sentencing Commission, which advises federal judges or provides recommendations to federal judges. So I just want to give you an opportunity today to share what studies, articles, books, law review articles, or commentary you have read regarding racial disparities present in our criminal justice system.
Well, Senator, as you know, the sentencing guidelines do give judges guidance on imposing sentences. And so I am familiar with the sentencing guidelines because there's something when we review sentences that, you know, we need to draw on and apply. In addition to the sentencing guidelines, the Sentencing Commission, as you say, does issue studies, or, you know, sometimes we get things from the Federal Judicial Center that talk about it. It's not something, I'm certainly aware of it. I think it's kind of an obvious point that there's still racism.
But
I
forgive me for interrupting, and I'm especially concerned because of
that's fine.
Joni Ernst, who's been teaching me about Iowa, and I do not want to make her mad. I was actually asking specifically any books you can name that you've read on this subject, or law review articles, anything that you specifically read outside of the sentencing guidelines.
Well, Senator Booker, I would say that what I have learned about it has mostly been in conversations with people and, you know, at Notre Dame, as at many other universities. It's a topic of conversation in classrooms, but it's not something that I can say, yes, I've done research on this and read X, Y, and Z.
I respect that you've answered the question. So, one of the greatest drivers of disparities, I've worked with partners of mine on both sides of the aisle, has been the so-called war on drugs, which really is a war on black and brown people because of the outrageous disparities. And there's no difference between blacks and whites for using drugs or even dealing drugs in America, but blacks are multiple times more likely to be arrested for them. It's why at Stanford, not that I'm impugning my school, lots of drug use, very little arrests, but in low-income communities like the one I live in, equal drug use, but much more arrests. One of the most tragic examples of this, again, partnership on both sides of the aisle, was about the crack powder cocaine disparities, which imposed such harsh, unbalanced penalties for cocaine relative to powder cocaine, that someone caught with a amount of crack cocaine the size of a candy bar would get a roughly the same sentence as someone caught with a briefcase full of powdered cocaine. This is a wildly unjust part. When the Sentencing Commission wrote an amendment to the address to address some of the disparities and made it retroactive to 2008, you actually wrote a law review article in a well-known legal academic, not a law review article, excuse me, you wrote a blog post in a well-known legal academic that cited this decision, and you questioned whether that was a wise call. Now, in fairness, as I reread it today, you raised the administrative hurdles in retroactively reducing sentences, which would provide relief to actually an estimated 20,000 Americans who had their liberty, one of the most fundamental rights, taken away from them. But never in the blog article did you mention that this was unjust. There was no deference to how serious this is for the 20,000 Americans, 98% of them who are black and brown. You just questioned, why are we doing this? Could you tell me why?
Sure, Senator Booker, I think what you're referring to is a short blog post on the Law Prof's blog, and it wasn't an in-depth exploration of the crack cocaine disparity or anything like that. It was simply pointing out the administrative hurdles because my husband was an AUSA, a federal prosecutor at the time, and that had been table talk at our house, just kind of the complexities of retroactively going back. So it wasn't a policy statement and it wasn't a statement meant to be just. I don't think it was probably more than a paragraph. And it was simply identifying the administrative hurdles because they're clearly, whenever you apply retroactive reform, there are administrative hurdles going forward.
Well, you're a law professor who assigns lots of syllabus to just a guy like me who played football. This is a long article, a couple of pages worth, and I'm wondering.
The blog post was?
I have it here in font that my old eyes can't read without glasses.
My old eyes can't see it from here either. I don't have a memory of how long it was.
I guess I'm just saying that you're not citing articles or research that you've read on this issue, yet you have written here about it, and to me that speaks. It makes me wonder and want to talk to you a little bit about your preparedness and priorities, taking the highest office in the judicial world that deals with such long-standing issues of race and in a way that affects the totality of the lives of Americans in every aspect of their life, from their financial well-being to their rights to vote. And I'd like to go through as quickly as I can in my remaining 10 minutes a little bit about the vastness of this problem. And why I'm very concerned that you haven't even cited anything that you've read that would speak to this, or the only writings I could find on it don't even talk to the injustice of it all. And so you had a conversation with Senator Klobuchar about voting, and I just want to know, have you ever waited 5 hours to vote?
I have not.
Have you ever waited over an hour even?
I have not.
Yeah. Well, in Wisconsin, a state in your circuit, we saw the travesty during the primary earlier this year, during a pandemic, that many polling places were closed and lines were incredibly long. In Milwaukee, a city of more than 500,000 people located in a county with 70% of that state's black population, we literally saw out of the city's 180 polling places, only 5 were open, pushing people into hours and hours long wait. Now, comparatively, 66 polling places were open in the city of Madison, a predominantly white city, half the size of Milwaukee. And the U.S. Supreme Court made this all worse with a ruling that restricted mail-in voting at the last minute during a pandemic where Black Americans are dying at twice the rate of white Americans. And let's be clear, this is part of a nationwide problem with racial disparities in voting. A recent study found that residents of entirely Black neighborhoods wait almost 30% longer in lines to vote. And they were 74% more likely to spend more than that half an hour at the polling place. Now, your dissent in Cantor versus Barr, you said something about virtue-based restrictions, which really raised my concern. And that virtue-based restrictions have applied to civic rights like voting and jury service, not individual rights to possess a gun. This approach to the franchise sort of pulls up a lot of history where people used virtue-based restrictions in the past that's been very well documented in our history. Ideas that you can disenfranchise people if they don't meet certain virtue tests. And many of these tests I know you're aware of, but these are like, are you worthy enough if you can't say the whole Declaration of Independence? These are tests that John Lewis used to talk about. Can you count the bubbles in a bar of soap? You're familiar with that, I'm sure.
Senator, I want to be very clear, and I tried to clear this up yesterday. This concept of virtue, I think especially for people who are watching this who don't know about the law, does not mean that I think that people's voting rights can be taken away because they're not good people, or that I think literacy tests are okay, or anything like that. It's a concept that was present in Heller. Cantor versus Barr was not about voting rights, and I very clearly have said voting is an individual and fundamental right that is critical to our democracy.
So poll taxes, you would say, unconstitutional.
Senator, voting is a fundamental individual right that is critical to our democracy. The 14th Amendment, the point I was making is that the 14th Amendment does expressly contemplate that states might deprive felons of voting rights because it's in the text.
So you're jumping to felonies. I just asked you about poll taxes. And I've tried to point out to you with the picture of just one place or African-American community as a whole, waiting so much longer than you and I might have ever waited in lines. I'm trying to draw something here for you. So I just asked about poll taxes, didn't get to felony disenfranchisement yet. Poll taxes, unconstitutional, yes?
Okay, I was pointing out with the felony disenfranchisement, the point I was making in Cantor versus Barr. I wasn't trying to anticipate your questions. I was just saying that that was the context in which I discussed it. I think Section 2 of the Voting Rights Act, which prohibits procedures and practices.
Right. I
Poll
think that,
taxes
thank
fall.
you. Yeah, thank you very much. Thank you very much. You're jumping ahead, and I spent so much time on my questioning. So let's jump, though. Let's jump ahead to this. And obviously, the case in Florida that you're well aware of, I imagine, where we had significant felony disenfranchisement. I've read a lot about the history of that going back to the post-Civil War period, the fall of Reconstruction, thousands of blacks being lynched, massacres going on in our country, from the Colfax massacre to the Greenwood massacre, and laws being passed systematically in places to try to make it harder for blacks to vote, designing felony disenfranchisement laws and putting those aside of the black codes, easy to disenfranchise lots of African Americans. So this is a lot of the historical origin here. Now, we see this coming to the fact that now we have places like Florida, and by the way, there are levels of disenfranchisement for African Americans upwards of, I think in America, 1 in every 17 blacks are unable to vote because of felony disenfranchisement. I can see by your expression that's a surprising data point. I hope that you would look at that. And yet in Florida, about 774,000 people have completed their felony sentences. They're now being prevented from voting because they still owe fines and fees. These are Americans, disproportionately black, are being subject to a modern day tax. In other words, if I'm wealthy enough, I can pay that. If I'm African American, disproportionately poor, I can't do that. 1 in 5 black people in Florida couldn't vote because of felony disenfranchisement. Now, this is well-documented history. I've gone through some of it. But as you are seeking this highest office in the land, I bring this full circle of our conversation because, again, another study by the American Bar Association, which I recommend to you, shows that a person with a felony commitment in America is subject to 40,000 collateral consequences. In other words, we now have in America the war on marijuana. It's affected, in 2017, there were more possession of marijuana arrests in America than all the violent crime arrests combined. Overwhelmingly and disproportionately African-American people. Saw it used at Yale and Stanford, not at Notre Dame, just played them in football. But my point is you see that if a black person is not more likely to use marijuana, but they're more likely to be convicted of a felony for it at some 3 to 4 times the rate, I hope you can see that that means that they're going to be more likely to lose other liberties, other rights. It so deeply affects their lives, their voting life, their ability to raise their children when a parent has been put in a position where now, because of that felony conviction for doing things that 2 of the last 3 presidents admitted to doing, they now can't vote, they now can't get jobs, they now can't get many business licenses. This is such a deeply affecting system that is disproportionately harming one class of citizens based upon race. And so here we are in the midst of and I return to the not normalcy of this moment in American history, where you can't turn on the TV and watch basketball without courageous athletes trying to talk to the heart of America to say, please listen. Please listen. The system is endangering lives, taking away liberty, taking away your financial well-being, taking you away from your children. There are people marched in all 50 states, 18 other countries, because African Americans, when they're jogging, sleeping in their home, are being killed. And we have a nation now where we're doing a Supreme Court justice hearing, the last days of an ongoing election, to a president that can't even condemn white supremacy, where he tells white supremacist groups, stand by, where they're menacing and literally recruiting people to do so-called poll watching, which many people have sounded the alarm in African-American communities, dredging up memories of the past of people intimidating people at polling places. People protesting in our country, all leading into an election where this issue and Roe v. Wade and people's health care, all is going to be on the ballot, but yet we're sitting here acting like this is normal. And I have a great deal of respect for my colleagues, because some of my colleagues courageously have stepped up calling out studies from and articles and writings from the Heritage Foundation, from the Cato Foundation, from AEI, who've all spoke to, with data and facts, the pervasiveness of racial disparities. The America, something's going on where the New York Times bestseller list, the Amazon bestseller list had books stamped from the beginning: The Color of Law, Just Mercy, The New Jim Crow, bestsellers all throughout America as people are seeking to know what the facts are. And so I hope you understand my heart when I look at a justice who it seems that, as the fix is in, is going to serve on the Supreme Court and hasn't taken steps to understand the pervasiveness, the facts, the truth about cases of race that are going to come before you in a system right now that so many people feel like is unjust, that those words written on the building of the Supreme Court, equal justice under law, doesn't apply to them. Because they see, as Brian Stevenson says, that we still live in a country where you get better treatment in the justice system if you're rich and guilty than if you're poor and innocent. And so I appreciate the conversation that we've had. And I wish we had more time. But there's a lot of fear, as I've talked to you about yesterday. There is a great deal of concern about the way this is being done. And I just am deeply, deeply worried about the implications to the fabric of our nation, as I said to you in our phone conversation, with the way this is being handled. And so I'm very grateful with the decorum and candor with which you've answered my questions. I hope that you feel like I've treated you in the same way.
Yes, thank you, Senator Booker.
Thank you.
Thank you, Senator Crapo.
Oh, I'm sorry. My staff is just telling me I should have said this.
Without objection. Whatever it is.
You and the justice are both trying to jump ahead.
Whatever it is.
I appreciate you, Mr. Senator, and the work that you and I
Thank you very much.
have done. So I would like to ask unanimous consent to enter into the record the following 3 letters into the record. A letter from the Leadership Conference on Civil and Human Rights opposing Justice Barrett's nomination to the Supreme Court, a letter from 83 young people organizations opposing the nomination of Judge Barrett to sit on the Supreme Court, a letter from LGBTQ advocacy groups opposing any nomination where reasonable doubts exist on her ability to administer fair and impartial justice for the LGBTQ people. Thank you.
Thank you. Without objection. Senator Crapo.
Thank you, Mr. Chairman. Judge Barrett, good to see you again.
Likewise.
Before I begin my comments and questions, I think there was at least an implication from what was just said that you would not be sensitive to the need for equal justice for all under the law, for all peoples in America. Would you like to respond to that at all before I go ahead?
I am fully committed to equal justice under the law for all persons. I am fully committed to enforcing all laws to prohibit racial discrimination. In my private life, I abhor racial discrimination, and obviously for both personal reasons and professional reasons, want to ensure that there's equal justice for all. And, you know, all of my children, I think, have made an escape, but if they watch this one day, I would want all of them to know, and especially Vivian and John Peter, that I unequivocally condemn racism and want to do everything that I can in my own capacity, personally and as a judge, to end it.
Thank you. I appreciate you making that point. I find it just incredible that a mother of children of different races could be accused of not being sensitive nor willing to protect the rights of all under the Constitution. Before I go on with my questions, once again, it's happened both 2 days ago and yesterday and again today. There's a couple of things I think that need to be set straight in the record. First of all, once again today, it was said that we should not be holding these proceedings because we should be dealing with the pandemic. Well, first of all, the Senate can do more than one thing at one time. Secondly, as I indicated before, we've put over a $500 billion package of relief dealing with most every important and significant aspect of our need for COVID response on the floor. It has been filibustered by the other side. The president has made an even larger offer back. That has been flatly rejected. And we have had an announcement recently by the leader of the Senate, Mitch McConnell, that we will vote again next week on the issue to see if there is some way we can get an agreement to move forward. But the argument that we should simply ignore this important nomination because of that holds no water. Secondly, another of the major points that this entire hearing was started out with on the first day was that people should be scared by these proceedings because they will lose coverage, healthcare coverage for their pre-existing conditions. That has been, again, run out here today, time and time again. And I'm not going to ask you to go through that again, but I'm going to make a couple of comments about that. As I said earlier in these hearings, even back when we were debating Obamacare, there was no disagreement about covering pre-existing conditions. And in every proposal from our side since that time, coverage for pre-existing conditions has been included. It is not something that there is an effort to or a willingness or a desire to eliminate in terms of protection, and it is not at risk in the Supreme Court case, as you have, I think, very clearly described in your testimony, Judge Barrett. And finally, with regard to that, if those assurances and those facts don't make it clear, Senator Tillis has introduced legislation called the PROTECT Act, which will put into law, once again, protection for pre-existing conditions in our health care coverage. And every one of my colleagues on the other side of the aisle voted no to stop that from moving forward. It's there. The bill, the PROTECT Act, is in the Senate. We can vote on it if we can just get permission to proceed to it from our colleagues. So this notion that pre-existing conditions is somehow at jeopardy is simply rolling out yet again in this campaign cycle, another one of the arguments that doesn't hold water. Now, I do want to move to some questions for you, Judge Barrett, and again, after it was extensively discussed yesterday and the day before, you have been attacked on the basis of concerns about your willingness to follow precedent and stare decisis. In fact, one of my colleagues, if I heard it right, said he thought that you may participate in issuing in a whole new era of judicial activism in overruling precedent of the courts and basically pushing an agenda that you won't admit to having. I know you answered this a lot yesterday. We're going to go through it again. One of the things that you were asked about extensively was this, I think, 2013 law review article where a sentence was plucked out of it that you feel was not correctly reflective of what you said and how you feel. Would you like to take an opportunity to clarify that for us?
Sure. That article was responding. So as I've said a couple times, the Supreme Court gives different precedential strength to constitutional cases than to statutory cases. And that article was responding to arguments that either stare decisis should be eliminated altogether or that it should be absolute. And I was taking the Supreme Court doctrine as it exists, where constitutional cases are not absolutely insulated from overruling, which is the position that every Supreme Court justice of whom I'm aware has had. Sometimes you do have to overrule cases, otherwise we don't have Brown versus the Board of Education. And I was just identifying some of the virtues of that presumption. So I was defending in that article the current Supreme Court doctrine of stare decisis, and I very clearly said in that article that you can't just impose a new vision with votes, that you have to take reliance interests, and that always lack of certainty about how the stare decisis calculus runs counsels in favor of keeping the status quo.
Well, thank you. Now, I found it amazing that you would be accused of being a judicial activist because you are a textualist and an originalist, as I understand your testimony and your record and your writings. And I'd like to just look at a few of your writings. You have described stare decisis as a fixture of the federal judicial system. You have stated that the Supreme Court, that you recognize that the Supreme Court follows a presumption that precedent will stand and that the court does not depart from that presumption unless the precedent is not only erroneous but unworkable, correct?
And not only erroneous and unworkable, but also has to take into account reliance interests and those other factors as well.
Yep, that was actually next on my list.
Sorry, I thought you meant unworkable was enough.
You anticipated that. And you have spent a lot of time, and I won't ask you to do it again, going through those requirements that are in place before a judge or a justice would seek to become an activist in the sense of overturning existing precedent of the court. And you've also said that partisan politics are not a good reason for overturning precedent. I assume that goes without saying, correct? Let's look at those are some of your writings, and you've written much more, but let's look at some of the case law. You've got a pretty significant record now in the Seventh Circuit. You have, as I see it, a pretty solid record there of following precedent. The first issue is in 2019, you had a discussion with Judge Amul Thapar.
Oh, yes, Judge Amul Thapar.
Okay, and I think could you please explain that conversation? It related, I think, to a case where you were clarifying that even though you disagreed in a previous circumstance relating to it, that you would follow precedent, or do you recall that conversation?
I recall the conversation. We did it for a professor in the political science department. It was to primarily an undergrad audience, and we answered questions back and forth on a range of topics. I don't remember the particular.
Okay, so this was not a case, it was a scenario you were asked about in that conversation.
Oh, okay.
And you made the clarification that in that scenario, you would decide a case consistent with the way the majority did and not with your own view if the precedent required it.
Oh, so if I had dissented the first time around and lost, and then when
That's
it came
apparently
around,
what that was all about.
Okay.
So let's talk about a couple cases. In Price versus the City of Chicago, you joined in affirming opinion over a district court's dismissal of a suit by pro-life activists. Do you recall that case?
I do.
What role did precedent play there?
Precedent controlled a case called Hill versus Colorado. The bubble zone ordinance at issue in Price was nearly identical to the one that the court had upheld in Hill.
And even though in this case you ruled against a pro-life interest in following precedent, correct?
Correct.
In Lett versus the City of Chicago, you applied the Supreme Court's test for evaluating restrictions on public employee speech. Do you recall that case? Yes. And
Yes.
again, you followed the precedent. In Chazen versus Marske, M-A-R-S-K-E, the Seventh Circuit held, in light of the United States v. Mathis and a subsequent Seventh Circuit decision, that a petitioner's prior convictions on a burglary no longer qualified as predicate offenses under a certain criminal act. Again, following precedent of the Supreme Court and the Seventh Circuit. I'm just picking out a few. You've got a very full record of these. In my view, I only found one case where you actually did not follow Seventh Circuit precedent. And that was the case of Groves versus the United States. And I don't know if you recall that case, but
I do.
why didn't you follow Seventh Circuit precedent then?
So in that case, there was precedent that was old, on point, and the Supreme Court had issued a series of subsequent decisions which called our prior precedent into doubt. And so the Seventh Circuit has a rule called Circuit Rule 40E, and when we conclude as a full court, you circulate an opinion to the full court to say, I think our precedent should be overruled. In this case, because it had fallen out of step with later developments in the Supreme Court, I circulated that precedent, or the opinion pursuant to 40E, and the full court agreed. So we overruled precedent.
So the way I would summarize that is that you, the court, with your support, overruled a Seventh Circuit precedent because a Supreme Court precedent overruled that. Pretty closely?
Not directly overruled it, but the Supreme Court precedent
Was inconsistent with
undercut it.
So you were
Undercut it.
following Supreme Court precedent to take that action.
Yes.
All right, let's just look at your cases. And I'm going to go through some statistics here. You know, statistics sometimes get outdated or what have you. So if these are not accurate in your understanding, please tell me. But what I have before me tells me that you've authored 79 majority opinions since arriving at the Seventh Circuit. Is that a correct number?
I don't know. So I will take your word for it. I think
All right, well,
yeah.
that's what my information says.
Okay.
And it says that you've participated in the disposition of 922 appeals. Does that sound approximately accurate?
I think I have, the numbers that I have looked at recently suggested that I've participated in 600 panels that were appellate, but close to 1,000 matters, which would include things like stay, certificates of appealability, stay applications, et cetera.
All right. And my understanding is, and again, these statistics might vary a little bit because the numbers are a little different than you say, but I think this is pretty accurate, that your majority opinions have been unanimous 95% of the time. In other words, almost always when you join a majority, it's a unanimous conclusion of the court or of the panel. Is that correct?
That's my understanding. I've seen that statistic.
Well, the statistics I see say that it's 95% of the time that it's unanimous for the decisions of the panel. According to CRS, Congressional Research Service, in all the cases you heard resulting in a reported opinion, you've only dissented 1.84% of the time. That ranks you 6th among the 11 active judges of the Seventh Circuit, which is right about in the middle. This report also says that your reported majority opinions drew dissents 6.41% of the time, which ranks you 6th among the 11 panelists, or of the 11 active judges, right about in the middle. And it says that the reported majority opinions drew separate writings or concurrences or dissents 7.69% of the time. That ranks you 8th among the 11 active judges of the Seventh Circuit, which means your opinions were some of the least likely to draw a dissent or a concurrence. the point of all these statistics is this is not the record of someone who is an activist in overturning precedent. This is the record of someone who follows precedent. And I just want to thank you for being that kind of a judge, because that's one of the reasons I'm so glad to support you as we move forward. Now, again, unfortunately, today, once again, and I thought we had this resolved yesterday, you've been challenged on what you knew about the president's positions on various issues and whether that influenced your positions. In fact, I think it was even implied that a law review article you wrote that was probably written before the president was even president was something that you were influenced in writing because you knew what the president thought. In any event, we're going to have to go back again and ask you these questions about, you've already said yesterday that the president didn't talk to you, his staff didn't talk to you, no one talked to you about Roe versus Wade, Obergefell, or California v. Texas, and you made no commitments on those three cases.
I made no commitments on any of those cases or on any other case.
That was my next question. Because today it's been implied that you've basically just been following the president's statements, his tweets, even things that he may have felt or believed before he was president, and trying to make your decisions consistent with that. So once again, has the president or his team or anyone talked to you about any case or received a commitment from you about how you would rule on any case?
No, Senator Crapo.
All right. I hope that we can once again put that one to rest. And could you also once again restate, is anybody above the law in the United States?
No one is above the law in the United States.
All right. Thank you very much. I told you yesterday before I quit that I was going to ask you a few softballs.
Sometimes softballs turn out not to be softballs. Go ahead.
Well, I think this will. I just want to ask you, I'm going to go, these are some of my hard balls. I'm going to leave those because I've only got 3 minutes left. I just want to talk to you for a minute about academia. What led you to your decision to move out of practice into academia?
Well, when I was in law school, I thought I might like to teach someday because I really like teaching. I considered being a teacher. I mean, being a secondary school teacher was actually one of the things I thought about too in college. As I said in my speech at the announcement of my nomination, that my mom was a teacher and my dad was a lawyer, and so combined that might explain how I wound up being a law professor. So I loved the idea of teaching students. I liked the idea of communicating with clarity, complicated doctrines to them to help them. I have very much enjoyed, teaching the 2,000 students that I've taught and mentoring them as young adults just embarking on their careers, and in many cases for those who have not had much time between undergrad and law school, even kind of launching their lives. It's been a really rewarding experience.
Well, you've obviously been very influential in that because so many of your students and your colleagues speak so highly of you. You actually also anticipated two of my other questions about it. So I only have one more to ask, and that is, what was your favorite class to teach?
Oh, it's hard to pick a favorite. It's like asking what's your favorite child, who's your favorite child. I really enjoyed teaching so many classes. I mean, constitutional law and federal courts overlapped directly with the things I was writing about. I taught evidence mostly just because they needed somebody to do it. And what's funny about that is, I didn't do scholarship. I didn't write scholarship about evidence. It wasn't part of my scholarly interest, and I was doing it as service. It's called a service class just because you need someone, everyone wants to take it. It turned out to be really fun to teach just because it was fun to be able to engage students in interactive exercises, and I could use movie clips to do it, and it turned out to be a very fun class to teach, even though it didn't overlap with the things I was writing about.
Well, thank you very much, Judge Barrett, and it is an honor for me to be able to support you for this nomination.
Thank you, Senator.
Thank you. Senator Harris, are you?
I'm here. Can you see me and hear me?
Yes, ma'am. The floor is yours.
Thank you, Mr. Chairman. Judge Barrett, earlier today you described the Voting Rights Act as, quote, a triumph of the civil rights movement. But as you know, the Voting Rights Act was not an inevitable triumph. So I think it's important for us to acknowledge some of its history. This year, our nation has mourned the loss of a great American hero, Congressman John Lewis. He was one of our country's greatest leaders because he inspired us to fight for a more perfect union. Every year, John Lewis would invite a bunch of us, members of Congress, faith leaders, others, to join him in Selma, Alabama, for a walk across the Edmund Pettus Bridge. And it was there that he would remind everyone of America's history and the history of the fact that for generations, Black Americans were denied their constitutional right to vote. He also reminded us of the brutality that so many Americans faced when fighting for the voting rights of Black people and all people. And history reminds us that some states, as a condition of voting, require Black Americans to answer impossible questions, like take a look at that jar of jelly beans, and if you're going to vote, you need to tell us how many jelly beans are in the jar. There were questions asked of folks. In order for them to vote, they would have to tell the official how many bubbles are in a bar of soap. Impossible questions, obviously. Some states required Black people who had been systemically and systematically denied access to equal educational opportunities to answer questions like, how often is the federal census taken? Or when is inauguration day? And when one of these malicious questions was asked, they were challenged, as you can imagine, and many were struck down. But when that happened, those states and municipalities would just put up new restrictions and new obstacles for folks to vote. In other cases, Black Americans were beaten when they tried to vote or register to vote, including Congressman Lewis and others who memorably shed blood on the Edmund Pettus Bridge. That's why after so much pressure and the marching, the peaceful protest from civil rights activists, that in 1965, Congress finally passed the Voting Rights Act to end discriminatory voting practices. The Voting Rights Act, as you know, requires states and counties who had a history, this is very important, who had a history of denying Black Americans and other minorities the right to vote, to get approval from the federal government before they changed their voting laws. And for almost 50 years, the Voting Rights Act did what Congress intended. It allowed the federal government to monitor and guard against racial discrimination in states with a long history of voter suppression. But as we all know, in 2013, in Shelby v. Holder, a county in Alabama sued to strike down Section 5 of the Voting Rights Act that required Alabama to seek approval from the federal government before a state could change its voting laws. And of course, Section 5 required that of a number of states that had a documented history of voter suppression. Now, Judge Barrett, I know many of my colleagues have asked you about this case, but I think it's important we revisit it. By a 5-4 vote, the court gutted the Voting Rights Act and ended the requirement that states and localities with a history of discrimination get federal approval before changing their voting laws. What the majority of the Supreme Court justices fail to understand is that the success in combating voter suppression directly was a function of our ability to enforce Section 5 of the Voting Rights Act. So the success was due to the brilliance of Section 5 of the Voting Rights Act, which gave us enforcement capabilities and monitoring capabilities. As has been mentioned, just 2 months after the court gutted the Voting Rights Act, North Carolina passed laws that made it so much more difficult for Black Americans to vote that a federal court of appeals mentioned that it, quote, targeted African Americans with almost surgical precision. Texas also has a long history of racial discrimination in voting and was therefore once also covered by the Voting Rights Act. But after Section 5 was gutted in Shelby, Texas quickly returned to some of its discriminatory voting practices. Of the more than 1,600 polling places closed after the court's decision,